You may be seated. Okay, we're back on the record in SA18CV00680, Zinter versus Salvaggio. Mr. Radner, we were just about to hear from you. Let me just for housekeeping purposes, I'll plan to give us a break for lunch. Why don't we do it at noon? We can come back at 1. And I'm scheduled to be on criminal duty this week and next, but I was able to get some help from one of my colleagues for cover. So I've blocked off today, hoping that we can get through everything we need to get through today. If we can't, we can continue later, but scheduling, I'll roll back onto criminal duty so this week and next I'll be on criminal duty, won't have an opportunity to have any kind of a lengthy hearing. The following week I'm traveling to D.C., but then after that we can sort something out. So just so everybody kind of knows where we are scheduling-wise, that's my availability.
Director, there is another agreement that we have.
Okay.
I know you love hearing all these agreements.
Yeah.
This is a minor one. Officer Farias, that's Farias, was feeling very ill, and Mr. Progerio and I agreed that he could go home, even though I was planning on calling him as one of my first witnesses. So he's not going to be here today. We agreed that I'll try to get what I can out of Salvaggio.
Okay.
Hopefully he'll know enough and be able to testify about what's contained in the police reports, even if they're written by other officers. And then assuming I can get what I need from him, then we're not going to need periods at a later date and time, but it's possible that we might. So I just wanted to read that.
Okay. No, thank you again, and thank you for working together. I love agreements about discovery in civil matters. That's how it should work. And so thanks for bringing that to my attention, and you can proceed. And then just another housekeeping matter, just make sure we're all on the same page. In this type of hearing, the rules of evidence are quite relaxed, and so that's sort of how I plan to proceed. Everybody's understands that as we're describing.
One last housekeeping thing. Can I ask for a sequestration order for purposes of this hearing?
What exactly are you wanting me to do?
When I call up one witness, I'm going to start with Chief Salvaggio, then I'm going to move on to Detective Terry Brooks. It's entirely possible, and I'm going to be cautiously optimistic and say maybe even somewhat probable that that'll wrap it up, but it's possible that it won't. If I have to call somebody else, I don't want that person to have been sitting here watching the testimony the whole day. I'd rather them come in without knowing what the other witnesses testified to. So it would just be a sequestration order as to the witnesses for today's hearing.
Well, in this particular case, we have most of the defendants. They're defendants in the case, so they're not subject to the rules. So the ones that are named defendants, I would request, obviously, they have the right to remain in court.
I agree.
Okay. All right, if we have an agreement.
It's just for any non-parties.
Okay, and we're in agreement with respect to this? Okay, all right, great. Well, we can proceed pursuant to that agreement.
I can get that. We would like to call. That's like to call Chief Salvaggio.
Affirm that the testimony you will give in the case now before the court shall be the truth, the whole truth, and nothing but the truth.
So let me go.
Oh, yeah, for the record.
My name is Joseph Salvaggio. That's S-A-L, V like Victor, A-G-G-I-O.
Are you familiar with the incidents that took place on June 14th, June 18th, and June 23rd of the year 2018 that bring us to court today?
I'm very familiar with all of them. I was present only for one of them.
Which one are you present for?
On the 23rd.
Have you had a chance to review video footage from the June 14th and June 18th incidents?
Some of the video footage, I don't believe there's so much. I don't think I've looked at everything.
Have you had a chance to review the police reports?
I've looked at some of the police reports. Again, I don't believe some of the supplemental reports possibly that I haven't read.
I'd like to start with the June 14th report. Your Honor, for the record, this is document 49-2. It was one of the defendant's response. I believe it was the city's response. I wouldn't bet the farm on it. I believe it was 49-2. Have you had a chance to review, well, can I go to the witness, please?
You may.
Can you please take a look at that and identify it for the record?
Excuse me, Your Honor, for the record, I believe that's the city's exhibit B2. If I'm not mistaken.
Well, let's all get on the same page then. What are we looking at exactly?
It's the June 14th report. It's document 49-2.
But it's exhibit B2. We have listed.
Yeah, it's rather than identify it by exhibit, because we're all going to have different exhibits at different depositions and hearings, I like to go with the ECF stamp because there's only going to be one. And the ECF number is 49-2. It's document number 49, page 2.
And Your Honor, I would, it wouldn't hurt to include the exhibit B2 because this document, it's just a better identifier, and we know precisely what documents we're looking at.
Okay, let me just make, I'm confused. So, I've got the CMECF open right in front of me for this case. I see document number 49, response to motion filed by the City of Leon Valley. And then it's got attachments, number 1, number 2, number 3, whatever. So which one? We're looking at one of those?
We're looking at exhibit B.
Or number 2, exhibit B. Okay.
And then within that exhibit B, there's a B2.
Oh, okay. Let me see. Gotcha. Okay. All right. In document 49, exhibit 2, B2. I found it. All right. Thank you.
Have you had a chance to review that document?
Yes, sir.
Is this the first time you're seeing that document, or have you seen it before?
It's the first time I've seen the supplemental reports that are attached to it. I've seen the actual office report.
And do you know if there's anything in there that's not true, or do you not know that?
I wouldn't know that, sir.
The officers who wrote the reports, do you have any reason to believe that they would not be truthful in their reports?
I have no reason to believe that wouldn't be true, sir.
Sorry, Your Honor, I gave my only copy, so I'm pulling up the other one over here. Are you familiar with the incident that was taking place?
Just what I've seen on YouTube and what I've read in the report.
The general allegations are that somebody was being arrested, somebody who's not a party to this action. Are you aware of that?
He's not a part of the action, but he's definitely a part of the group.
What do you mean by that?
He's exactly why they're all down here. He called for the officers to come down here and disrupt our police operations.
He called for them, and that's why they came down?
Absolutely.
How do you know that?
Because we have video of them doing just that. We have videos of your defendants doing just that.
What I'm asking is, how do you know that the reason dozens of people were outside protesting you and your department is because that person, whose name is Bo, right, B-A-O? Bo?
No, it was Jesus Padilla.
Jesus Padilla, okay, so Jesus Padilla was being arrested. On June 14th, Jesus Padilla was arrested?
No, June 14th was when everybody came down for 11 days and began disrupting our police operations.
Right. So I'm not talking about the May incident where Jesus Padilla was arrested. I'm talking about June 14th.
What I'm telling you is from May 2nd through June 14th, there was planning, organization, and videos that we do have copies of where they all came down at the request of Jesus Padilla, and it was an intentional act by a group of people to come and do what they did. The very first ones, we had people coming from May 2nd, including members of your group, that came from May 2nd all the way to the next arrest of Mark Brown, one of the plaintiffs that you're talking about. And the same day we arrested Jesus Padilla again. In between there, many of your defendants came and continued to do audits and disrupt, but they were not arrested. And so starting on the 14th through the final arrest on the 23rd, there was 11 days of disruption by members of your group and Jesus Padilla.
Okay. So let's talk about June 14th for a second.
Yes, sir.
This incident, in your opinion, was directly related to the May incidents in which Jesus Padilla was arrested, true?
According to what your defendants put online and stated, absolutely, sir.
So that's correct,
Yes,
right?
sir.
And in your opinion, did these people on June 14th have the right to be outside protesting or not?
Everybody has a First Amendment right to protest, peacefully protest. They all have a right to commit crimes in the name of the First Amendment.
Okay. And I'd like you to please tell me by looking at the police report from June 14th, or if you know from your own knowledge, that's fine as well. Tell me which crimes were committed on June 14th which justify the two arrests that are referred to in the June 14th report.
Jesus Padilla, who's been arrested previous to that, I think 2 times, and been warned, came back on the property with Mark Brown, walked up on the steps while he filmed Mark Brown coming in to disrupt municipal court operations after they'd already been notified of contempt of court would occur if they did it. They came back anyway, and he's our defendant, but your plaintiff refused to stop filming inside the building, so he was asked to leave the building, and then he was told where he could, very, very plainly, where he could film from, and instead he went and disrupted the arrest of Jesus Padilla. They came back on the property again illegally, and was arrested for criminal trespass. He did not resist, but your defendant began to interfere, violently interfere, and was arrested for that interference and resisting by the officers.
Okay, so Jesus Padilla was being arrested, and Mark Brown was interfering in what way? Specifically.
I'm going to give you some great specifics. Mark Brown was advised where he could film from. We have no problem with.
Let me just interrupt. Who advised him?
Our Sergeant Rialis. It's on video.
You saw the video?
Absolutely.
Sergeant Rialis went over to him and said, "You can video over there."
He told him you cannot video inside. You can video right here at this pole or across the street. He gave him direct orders. He immediately came right up behind him again, lording over. The gentleman's 6'8", probably about 250 pounds. He's a very huge man. Lording over him with his cameras right over his head as he walked back inside to get other officers to go arrest Jesus Padilla. So right off the bat, he began to interfere. When Sergeant Rialis came back out to make the arrest, instead of staying where he was told he could film from, he approached Sergeant Rialis from behind in a very aggressive manner, where they had to step in between him, stop him from doing that. He was told repeatedly, and it's on video, to get across the street. You cannot interfere with this investigation or this arrest at this point. And he was ordered 6 times by another officer that he needed to stop resisting, and then eventually he had to be taken down, which took 4 officers to take him to the ground due to his large physical stature. And this was all right on the heels of where the arrest is being made of Jesus Padilla.
We're going to watch a video from June 14th. You referred to the video several times. This is a video which was just given to me today, Your Honor. I do plan on, we'll see if I can mark it as an exhibit. If I do, it can be a little bit tricky because large flash drive, lots of individual files, but I'll figure out a way to get it to you. For purposes of the record, it's a June 14th video, and the file name is 1176 at 2018 0614 135 2260. Can I borrow it?
You may.
Sorry, I don't see it.
seen this video.
Okay, and let's just hold on. Have you all seen it, Mr.
We provide.
Okay.
See,
Are you familiar with which video, or you want to come around and take a look? You can. Just come where you can see. It's fine.
Just gonna pause for a second. 37 seconds in. Where are we right now in the video? Where is the person standing? Is this in the police station?
This is the hallway of the police station right now. And more than likely, they were watching the arrest start, so the arrest has already been going on for some time. They're watching it live
How are they watching?
on YouTube.
Okay, and pause 56 seconds in. Over here we see a gentleman toward the left of the screen bent over with two officers behind him. True?
Correct.
That would be Jesus Padilla.
Yes, sir.
The gentleman standing over there with the camera and the hat and the light gray short sleeve shirt, holding what appears to be some sort of recording device, would be who?
He's holding two recording devices, and that's Mark Brown,
Mark Brown. And in fact, he's standing right by the pole, right?
which is just a few feet away from where the arrest is being made.
Before you testified that he was allowed to record by the pole, right?
No, sir. I said the pillar,
By the pillar.
which is over here to the right, and he left that place where he was told. He never stayed.
You're talking about this
No,
line over
no,
here?
no. I'm talking about
Okay, there's something else.
way up there.
At this point in time, has Mark Brown committed a crime?
No, he's not, because the officers are going to wait to give him the demands at this point of where he can be, and that's at the point that he starts violating the law.
This is where he's aggressively luring over the arresting officers.
The lording over originally was over Orvialis, Sergeant Orvialis. You can see it if you watch the other videos. This is just one angle of what occurred.
Oh, so there's another angle that shows Mr. Brown lording over these officers?
Absolutely, and there's original evidence on YouTube that's very, very pertinent to us that we haven't been able to see.
During this arrest? right?
Absolutely. Including what's being filmed by Mr. Brown. We don't have that evidence based on the blocking of the subpoenas, that we really need that evidence,
Okay.
original evidence.
Now, at this point in time, is that gentleman in the light blue short sleeve shirt, who's that?
I assume that's Detective Wells, but I can't see his face.
And who's the gentleman to his right in the dark blue short sleeve shirt and the hat?
I have no idea.
But this is where the officers are going to tell him, you're interfering, go record somewhere
Now,
else.
he's already been told before not to interfere in where he can record. This will be the second time that he's told.
But he's going to be told, go record somewhere else, right?
I would assume, but we can play it and watch, but that's my understanding.
Okay, so because he hasn't committed a crime yet, right?
Again, no, he's not committed a crime yet, but when he refuses to move when he's told in just a second, that's when he begins interfering and he's committing a crime. He's way too close to the back of those police officers. For the safety of those officers, at this point, he needs to move.
Okay, so let's see.
Now he's in the street, which is a dangerous situation. He's being told, move. He needs to move back.
Okay.
So he needs now to get across the street as quickly as possible, not continuing to have an argument with the officer at that point.
Okay, so for the record, we're at 102 right now. And an officer, the gentleman in the royal blue short sleeve shirt, kind of heavy set, no hat, kind of was coming over to Mark Brown and telling him to leave, right?
Telling him to go across the street.
Right, and Mark Brown is now, at this point in time, we're almost 6 seconds later. He's in the street, right?
Told to go across the street. When
Right.
did he get in the street?
Right. You can't get across the street without going in the street, right?
You don't have to stop either.
Did somebody just say I'm pause at 107? say you're going to get tased?
No, he said, do what he says. Do what he says.
Do what he says. Okay, let's back it up a little bit. So we're going to go to 1 minute. We'll pause at 1 minute now. Here we see Mr. Brown's hands are up, right? His hands are up. Not assaulting anybody, not threatening anybody.
He's not assaulting anybody, but he's a very threatening person, and it's very threatening for all those officers to have that situation going on when an arrest is trying to be made.
And during
very
the
disruptive.
And during the arrest, he was lording over those arresting officers, right?
Go back to another video and another angle, and this is exactly why we need the original video, Your Honor, because every angle shows a different thing. And what you see in another angle that I'm sure he's not going to show you today from his own defendant's YouTube accounts is the lording over the original officer and right over his back as he turned around to go get other officers to arrest Jesus Vivian.
The records are not going to make much sense. My clients are the plaintiffs. You and the other officers are the defendants.
I understand, but they're defendants to us.
Make sure you, also, Mr. Render, make sure you speak up a bit because you're not right next to the microphone.
Okay.
I want to make sure that we're picking up what you're saying.
Okay, so now we're at 1 minute, and we're going to push play again. Do what he says. That's what he's saying. Not you're going to get tased.
No, he said that next time. After the first time he said, do what he said, and then eventually said you're going to get tased because he's not doing what he's been ordered to do. He's being ordered to go across the street and quit interfering. Multiple times.
Tell me this, who said that order. I'm going to back it up one more time for 1 minute. I'd like you to tell me who says that and go across the street.
It's not in this video, which again is why we need all angles of the video, but we do have a body cam video where, and he can testify to saying it, he told him multiple times to go across the street and quit interfering.
He's being arrested right now, right?
Yes, sir.
What's he being arrested for? What crime?
He's interfering with the duties of a police officer. He's been told multiple times to go across the street. He's refusing to do that. He continues to stand there and debate the argument of whether or not he has the right to do what he's doing on what he calls the sidewalk. It was not about the sidewalk, Judge. It was not about his filming. It was about the close proximity to the officers and the attention he was taking away from all the officers, focusing on the arrest.
Once he was in the street, he was no longer a threat to the officers.
That's completely not true, sir.
Even though he was no longer lording over them, which is shown on some other video that I don't have or I haven't seen, but he's lording over those officers, even though he's not doing that anymore. And now he's not only not even on the sidewalk, but he's in the street and backing up as the officers are walking towards him with his hands up. He's still presenting a threat to the officers, interfering with them, and therefore subject to arrest, correct?
That's a completely false statement you just made, sir. His hands were not up. His hands were filming. He's got cameras in his hand. When he came into the courtroom, in the court area, he was doing the same thing. He does that because he's 6'8", and the officers cannot reach his hands and cannot reach the camera. So it was not that his hands were up. He was doing that to keep the officers from doing anything with his cameras. He was not backing up. He took a step back. There's only about a foot between where those flagpoles are and the curb. He stepped back with 1 foot onto the street and refused to continue on. That's why he was arrested, because he continued to interfere and take away from our officers' attention to arresting Jesus Vivian.
Is Mr. Brown a part of this, I want to use your words, is Mr. Brown a member of the cabal, Salvaggio communicators who attempt to bring chaos and anarchy in the country?
But say that again.
Is Mr. Brown a member of the cabal, Salvaggio communicators who attempt to bring chaos and anarchy on governmental entities?
Absolutely.
And that's where he was arrested, right?
No, it's not. He was arrested for interfering with interviews with a police officer.
But if he wouldn't have been a part of this cabal, would he have been given another warning or two, or would he have been arrested the same way?
He was given several warnings, Judge. He was told multiple times what he couldn't do. There's other body cam footage that shows him arguing in the area where he was not supposed to be with cameras. He's notified multiple times inside before they got him outside. And then outside on camera, we have video of him being told exactly where he can stand. And he continued to disobey those officers and continued to interfere. Immediately, we don't care whether he films. We didn't arrest him for filming in there, and he received multiple warnings. It's not about the First Amendment, Judge. It's about him breaking the law.
And I just got these videos this morning. I just kind of looked through them earlier, and had a break. I hope that your attorney will be able to play the video showing Mr. Brown lording over the officers, because it certainly wasn't. And you would agree that it was not in the video that I showed you, right?
Right, absolutely.
And also the 6 warnings that he got, being told to go across the street while he was recording, that's going to be recorded on some other video, right?
Absolutely.
Because it happened, right? It sure happened.
I think I've already answered your question.
And do you know that it happened because you saw the videos? Or
Absolutely. I've seen the video, sir.
Where did you see these videos?
In my office?
Live at the time you saw the videos?
No, I didn't see it live. I wasn't present. No, sir.
When? So at a later date time you were able to watch the videos?
Yes, sir.
Where did you get those videos from?
The videos that I have seen were either the body cam videos or one video that was uploaded on YouTube. I believe it was from Jesus Padilla, the original person that was arrested from this group.
So you were able to watch it on YouTube because it was being streamed live on YouTube, right?
I can't say it was streamed live, or sometimes they stream them live, sometimes they just record them and upload them later. I'm not sure which one it was.
Okay, but the videos that you're talking about that show the criminal activity, you watched on YouTube.
Actually, on this one, I have seen one on YouTube, but the first video I believe I saw was actually after we received the search warrant for the items in Jesus Padilla's devices after he was arrested, and I've watched those videos as well.
Oh. I'll indicate for the record I have not received those videos, as far as I know. The videos that I have are body cam footage of the police officers.
What are these videos? Sorry?
It's a non-defendant that he's talking about, and I have not seen any requests from the attorney for videos that happened on May 2nd. None of that.
I'm talking about June 14th. I'm not talking about May 2nd. You keep talking about May 2nd. I'm talking about June 14th.
Yeah.
Let me ask the question. You saw videos from June 14th that show Mr. Brown lording over the arresting officers, being told to go across the street, and being warned 6 times, right? You saw those videos?
Yes.
Okay, and you saw those videos in your office, right?
Now, let me correct one.
Wait, you saw those videos, yes or no?
Yes.
Okay, do you still have the items belonging to Mr. Brown, the items that were seized?
We had the evidence that was seized in his arrest. Yes, sir.
When you watched the videos, did you watch it on Mr. Brown's?
No, absolutely not. We've not seen anything from any of your defendants. We've not received anything from the organization that's downloading them. We've not seen anything. We've not received anything. The warrants had already been served. We had taken them over there and dropped them off. But at this point, we don't have any of those from the 14th, or the 14th, 18th, or the 23rd.
And in the video, we see Mr. Brown, you said, holding 2 recording devices, right?
Yes, sir.
And both of those were seized, and both are still in the possession of the Leon Valley Police, correct?
No, sir, they're not.
Where are they?
We took them over and had them dropped off at the district attorney's office who does the downloading. I would assume, I've been told all of them were taken over there and dropped off after the search warrants were signed, but we have not received anything from them, and we've not seen those videos whatsoever.
Are you sure there are warrants from the June 14th incident?
I can't say that there are warrants for the 14th. I think the only stuff that actually we've got the warrants for at this point are the 23rd. I haven't seen anything from the 14th or 18th, and I'm not sure that anything has been downloaded or received. So we wouldn't have because we've not got the warrants yet.
Did you see the affidavit that was signed by Brandon Ramsey in this case? I'm going to give it to you. I'm just asking if you saw it.
Not that I remember, sir. I may have. I don't remember this.
Your Honor, I just want you to take judicial notice of, I would ask the court to take judicial notice of document 30-2, page 2 of 2, page 1 of 2, and page 2 of 2.
Okay,
And this is a
hold on here.
CF 30-2.
Okay, yep.
begins, I have also reviewed clauses 577193, and then continues on the following page where it ends with this time.
Okay?
Again, assuming Brandon Ramsey was telling the truth in this affidavit, there are no warrants in the June 14th incident, at least as far as Brandon Ramsey is concerned.
Correct.
Okay?
That's
We're saying the same thing.
Okay, so the video that you saw of this June 14th incident, you do not need Mr. Brown's property to see those videos, do you?
Yes, sir, I do.
You do.
I need Mr.
Wait, it was a yes or no question. Let me try to move on so we can get through this. Okay? You saw the videos that prove that he was guilty, true?
Yes, I've seen videos that prove that he's guilty, but
And
that's
you
not my decision. That's a judge's decision.
And you have not yet seen any of the video that's on the two devices, at least the two recording devices, that were seized from Mr. Brown on June 14th, true?
Correct.
Okay. Why do you need that?
Your Honor, we need the original videos of the people that were involved in this. There's angles, as you saw, you couldn't see the initial stuff that was going on with the defendant. You also have the YouTube Live that goes on with the comments and the rest of the evidence that goes along with the pre-planning and the additional evidence that should show and will show that this is evidence of a larger group. And in our long-term goal of filing additional charges on them, we believe that there's original evidence on those items that we do need.
What evidence?
Evidence of collusion, evidence of working together as a larger group in hopes of filing the additional charges that we plan on filing.
So just so we're clear, the items that you seized from Mr. Brown on June 14th, you're not keeping those to be able to establish that he was guilty of the crimes for which he was charged. You're using it to try to prove this greater conspiracy thing, right?
That's not a true statement.
Then please explain it, because I didn't understand.
Okay, let me explain again so you can understand. We need it for the original evidence. We need the items to show what Mark Brown was seeing, exactly what he was seeing at that time, and exactly what his actions were at that time.
Why? If you already have the video footage,
It's original evidence. If I showed up in court with something I got off of YouTube, any other attorney would understand that that's not the appropriate venue or medium that you should utilize. You should always bring a copy of the original evidence. That original evidence is on Mark Brown's phone.
So you're saying that when you stream something on YouTube, when you do YouTube Live, that there's an original copy of that video kept on the recording device, right?
There's an original copy on the recording device, and we don't know whether he's streaming YouTube Live. We have no way of knowing what he's doing. We didn't at this point even have his name yet. So we had no way of seeing his angle or getting it off YouTube Live until we identify him. And we go through every video he is involved in to figure out what's going on with this guy.
Whoa. Okay, that, I don't want to get into here. Let's say there's one video that you saw on YouTube Live and you think that there's a saved copy of that on his phone.
Oh, I'm sorry, man.
You believe that there's a saved copy of his YouTube Live video on his phone based on your misunderstanding of how YouTube works. But what you just said is that there's other videos showing other things to show what's going on with Mr. Brown. That's what you really need to see, right?
So your
Can you
characterization...
answer the question first?
I'm going to. Let me, sir.
Okay.
Your characterization of misunderstanding that I have is completely false. I don't have a misunderstanding of how YouTube works. What we have a misunderstanding, and you have a misunderstanding, and you continue to say, is that we can just get it off of YouTube. We don't even know if he was on YouTube Live at that time when the arrest is made. We have no way of knowing until after the fact whether or not the original evidence is there or if it is on YouTube Live. We have no way of knowing who he is until we put handcuffs on him. So we can't even chase his fake name of Too Tough Police Sub on YouTube until we know that his YouTube name is Tough Police Sub. So we don't know what is on YouTube. We can only assume that he is filming it and the original evidence is on that camera.
Okay, let's try to split this up into two different things. There's the June 14th criminal offenses.
Yes.
Item 1. Item 2 is the cabal of anarchist conspiracy. That's item 2. Okay?
I would disagree that they're separated, but go ahead, sir.
Okay.
They're all connected.
Well, for
All 11 days of this are connected.
we're going to get through this a lot quicker if you just answer that question.
And I did.
So, for purposes of number 1, if you have video that shows the testimony that you claim you have video shows that, you don't need Mr. Brown's property to prove the crimes that were alleged to have been committed on June 14th. True?
Untrue.
Okay, thank you. Now, the second item, the cabal of anarchists, the communist anarchist cabal, okay, the conspiracy of interrupting governments. There might be other videos on Mr. Brown's devices that will be evidence of that, right? Now, I know you think they're the same thing, but you think that there's videos on Mr. Brown's items that were seized by your department on June 14th that are going to show this greater conspiracy. True?
We don't know what is on his camera and his phone, so we are able to see him.
And the reason that you guys want to keep it and get search warrants for what's on that is to be able to prove this conspiracy and this cabal of zealots, right?
No, the reason we want to get the original evidence that's involved in this case from his phone is because it is the original evidence involved in this case on his phone. If at some point it shows something else, we'll deal with that accordingly.
Okay. Can I have a question on Chief Document? You think? Let's go back to June 18th. Are you familiar with what happened on June 18th?
Yes, sir.
Let's call this the obstructing the doorway date.
Yes, sir.
Approach.
Right. Can I ask for some water, please?
Sure.
Well, my God, okay. Sure.
I think we can probably get some. Okay, here you go. Come on up.
Thank you, sir.
Thank you. Thank you for asking.
Then I hand the witness what's previously been marked as document 49-3. Sorry, filed as document 49-3. The ECF stamp on the top says page 1 of 15. And I am giving the witness all the way to page 15 of 15. And again, it's 49-3.
Okay, got it. Thank you.
Now, just so that I'm sure that we're looking at the same thing, can you please turn to the page? I believe it's page 5, and I have a different version of this, but the one that starts with narrative on the above date BAP1. See that?
I'd like first to just make sure this is the documents on here.
Yeah, and the document 49-3 that I have on page 9 of 15 is the first place I see narrative. On the above date, the AP1 and several other male agitators / activists. Is that probably in the same spot?
Yes, and mine is, just so that the record's not unnecessarily messy, mine is 46-4, and it also starts page 5 of 13. I'm not sure why there's different versions of this, but I want to make sure that we're looking at the same thing.
Okay.
Okay, thank you.
Mine starts on page 9 as well, sir.
All right, thanks.
Okay. And you see that, sorry, let me know when you're done.
I've read the author's report, not had an opportunity to read the supplemental reports that are attached to it.
Did you watch any video footage of this incident?
After the fact, sir.
And did you see the door being obstructed?
Yes, sir, on video.
And there was somebody who, on 2 different occasions, Lieutenant D. Anderson, 502, told the agitators, activists, not to intentionally block the doorway, not block the passageway. Right? Is that true?
I'm sorry, what was your question?
On 2 different occasions, Lieutenant D. Anderson, 502, told the agitators / activists not to intentionally block the passageway into the building. Is that true?
Yes, sir.
And then AP1. Who's AP1, by the way? I think it's David Bailey.
Arrested one is defendant David Bailey.
Oh, David Bailey. And David Bailey, and this case is actually still pending, right?
Yes, sir, it is pending.
And there were a lot of items that were seized. If you look through the report, you'll see a long list of items that were seized on June 18th, true?
Yes, sir.
And that's because there's going to be evidence of Mr. Bailey's crime on those pieces of property, true?
Correct.
Okay, now let's take a look at this crime over here. If you continue looking, it says that AP1 7 lines into the first paragraph of the narrative, the AP1 intentionally and knowingly positioned himself in front of and obstructed the entrance with his body to the extent that his obstruction physically prevented a member of the public from entering the building, in which he was identified as W3. You see that?
Yes, sir.
Okay, so let me make sure I understand what's written here. Okay? You saw videos and you know this is true.
Yes, sir.
So David Bailey was blocking the doorway. Somebody tried to get in, couldn't, because he was blocking the door, right?
Yes, sir.
And he refused to move and let her in, right?
I didn't say that, sir. You did.
Oh, so well then what happened? Did he move and let her in?
So, then when he saw the officers coming for him, he stepped to the side because he'd already been warned 3 times that day, 2 by Lieutenant Anderson and 1 time by Sergeant Leavis. And he knew they were coming.
Okay. Did he intentionally block her or not?
And the answer was yes. He intentionally blocked the door. It's not relevant whether he blocked an individual. The law prevents him from blocking the door, period. It was just after the 3rd time that he had been told, 3 times he had been told, the decision was finally made to make an arrest, which we didn't want to do, but could have made the arrest the first time that he did it.
So it's your opinion that if somebody stands in front of the doorway, even if nobody's trying to get in or out, he's just standing in front of the doorway holding up a sign, that's a crime, right?
If he intentionally blocks the door, he is committing a crime according to the Texas Penal Code.
So if somebody stands in front of a door and blocks the doorway, that's a crime, right?
If somebody intentionally blocks the door, it is a crime. I'm agreeing with you. Yes, sir. Absolutely.
No, you're not answering my question. What question do you think I just asked?
Whether or not somebody commits a crime if they intentionally block the door.
Okay, so that's the misunderstanding. That's not what I asked.
Okay.
What I asked you is if somebody stands in front of a doorway, did he commit a crime, yes or no?
If he's standing just in front of a doorway, no. No.
What if he's holding a flag that typically law enforcement finds offensive? Then has he committed a crime?
A flag that law enforcement finds offensive, I don't
Let
know.
me ask you this. Mr. Bailey was holding a flag of some sort, right?
He was holding a flag and a flag pole, which have blocked both doors.
The police report indicates that he physically prevented a member of the public from entering the public building. Is that true, yes or no?
Again, sir, yes, it is true.
Your Honor, this video is June 18th, and it is 1056 at 2018 0618 134 1390 is the file name. And can I first look at this?
You may.
You might want to call the coach. And I'm starting from 457 into the video. Okay, pausing it at 5:06. Has a crime been committed yet?
I can't tell, sir.
Or take a look.
No. I'm tell because I don't know if this is before he blocked both doors with it or after. I can't tell at this point.
So I'm not asking you what happened before or after. I'm asking you right now when you see a crime.
And I am answering you, sir. I don't know. I cannot tell. I don't even see in that shot, and this is why the original evidence from the rest of the people in there that came in there to videotape this little action, why their stuff is so important, because you can't tell even where your defendant is in that shot. I have no way of knowing here.
All right. Back it up to 450. 50. All right, so we're paused at 5:03 right now. And I'm just asking you, just based on what you see here.
I don't even see David Bailey in the shot, sir. So the answer would be no.
You see the flag?
I see a flag, yes, sir, and a flagpole.
Who is holding that flag?
I have no idea. No, from this picture. If you're asking me to go just strictly off this picture in this shot, this video shot, I'd have to answer I don't know.
But you testified before that David Bailey was the one holding the flag.
But you're asking me to testify off of this shot right here. Now, do I believe that that's David Bailey based on something else? Yes.
Let me ask you this one. The person standing there with the shorts, whose leg you can see at the bottom of the doorway holding the flag, is that individual committing a crime based on what you see in this picture? Yes or no?
Not based on what I see, no.
Great. How about now at 5:13 when
No, sir.
somebody's stepping on the flag?
No, absolutely not. The Constitution protects it.
You find that offensive?
No, I don't find it offensive. Only flag I care about is the United States American flag, which I fought for.
You know what flag that is, right?
It's not a flag as far as I'm concerned. But yeah, I know what you're trying to get at. It's a blue line flag that we find offensive for somebody to desecrate. But Your Honor, that is completely misstated, completely.
Okay, let's keep going. Yeah, here we go. Now we're going to pause at 5:22. You see somebody just opened the door?
I see an individual open the door, yes.
Somebody just opened the door. You see that?
Yeah.
Did you understand? And you can see directly to her because nobody's in the way, right?
Correct.
Okay. Let's play it to the end just to make sure that somebody doesn't come now and interfere with her ability to get in the building. In fact, right now it's 5:28. Somebody blocked her from coming in the door, right? An officer did.
I didn't know this.
You didn't see that? Okay. Let's keep playing. And now we're at 5:32, and he's committed a crime, right?
No, I don't know, like I explained before, whether what the arresting officer saw was previous to that or not. And I don't know. I don't know at what point. But I've seen video of him blocking both doors with the flag.
Okay. Not on this video.
Not on that video that I can see, sir.
And also in this video, he at no point in time intentionally blocks a member of the public from coming in the building, right?
Not that I can see, sir.
Right. In fact, the police report contains a lie, doesn't it?
No, it does not.
It doesn't contain a lie when it says that the obstruction physically prevented a member of the public from entering the public building. That's not a lie in your opinion?
I don't know what you're showing right there, even is that statement in there. I don't know if they even match. I don't know.
Maybe on direct, your attorney can show the video that shows something else. Now, I got a whole bunch of items were seized based on the heinous criminal activity that we just saw in that video, right? All right.
I'm sorry, sir.
A whole bunch of property was seized as evidence, potentially.
There was evidence seized of the crime, yes, sir.
Right, of that crime of blocking the door.
Of a crime of obstructing a passageway.
And because of that criminal activity, how many items were seized? Can you take a look and tell me how many items were seized by the police as potentially containing evidence of that crime?
There was, from what I can count here, 11 items seized and 1 item that was abandoned that we still don't know the owner of.
Oh, Mr. Pierce, isn't it? In fact, the report says that you refused to sign the property receipt, doesn't it?
He refused to even identify the home.
Right. And that would be on page, we'll get to that soon, but that was Mr. Pierce's property. The property is, we don't know who the owner is. Right?
Again, Mr. Pierce, if he's going to claim his property, he signed that property receipt, say it's his. It was dropped in the commotion, it was found on the floor, we needed him identified. We attempted to get him identified, Your Honor, and he refused to sign anything. We attempted on multiple occasions to get him to sign it, and he wouldn't sign saying it was his phone or identified as his phone.
He probably just asked for his property back. He said, give me my property when you leave. Right?
That's not what he said.
That's not what he said? He didn't ask for his property back?
He didn't ask me for his property back, I can tell you that. In fact, no, not anything I've seen.
So 11 items were seized as potentially containing evidence of the criminal activity that is not depicted on this video, but depicted on another video you saw, right?
Well, let me actually go back. If you're asking me if he blocked a doorway and a passageway, he blocked a passageway. So there is an offense already. If you're asking me if that's the same lady that was involved, I don't know.
Those 11 items that were seized, has your office or anybody working with your office, any law enforcement, submitted any affidavits or requests or warrants to see the evidence that may be contained on those 11 items?
Not that I know of, sir.
And the reason that they were seized has nothing to do with the fact that they were protesters, right? That's not why it was seized.
This was not a protest in a foyer between 2 small doors. That's not a protest, sir. They came in, they specifically left together, went and concocted a plan. We know this, that part's on video. They told everybody to shut the video down, went and burned the flag, which who cares, came back with the flag and walked up and down the street. We're not getting any reaction for us for some time. So they sent a couple of people, I can't remember if it was 3 or 4, into the very small foyer and waited until he came in with the flag. So there's some collaboration going on. There's some additional crimes that if we can show that collaboration, which we believe we can with the videos, that will be filed on everybody that was in that foyer.
Tell me what crimes, what additional crimes?
The state law and Texas Penal Code of riot, not in the...
Did you say, I'm sorry.
Yeah, riot.
Riot.
Yes.
This was a riot.
Let me finish. Not in the normal traditional things that you would describe as a riot, but considering the fact that in the state of Texas says impeding governmental operations, and this is beyond just that incident that's going on at that time, Your Honor. There are hundreds and hundreds of phone calls coming in, emails, their complete disruption of our operation that day, the death threats that were coming in, all of those things are occurring, including death threats that are coming in from people that are saying they're there, present, and are going to kill us. People walking around with guns. So this is not just an isolated incident with individuals that just happen to be hanging out on the street. They're all together, and it's a coordinated effort between a coordinated group.
Okay, so let me ask you this. Were these 11 items seized because they potentially have evidence of Mr. Bailey's crime of blocking a doorway, or because it might have evidence of the other things that you just described?
It's got evidence of both, sir. When we got the search warrant at the time, we got the search warrant, or if we get a search warrant, we'll get specific search warrants based on the thoughts of which crime were being committed at that time.
And to date, not a single warrant has been submitted for a single one
No,
of those
sir.
items?
Our operations have been so diminished based on this group's continued effort that we can't even get to filing those.
Because I have over here 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 affidavits and warrants that you guys managed to find the time to submit requests on, right?
Correct.
But those are from June 23rd, 2018. You haven't found 5 minutes to prepare a warrant based on this June 18th riot. You haven't found the time to submit a warrant to uncover evidence of this conspiracy to plan a riot. Is that your testimony? Yes or no? And then you can explain.
No.
Okay, what's your case?
So these are happening back to back. Discussion with the district attorney's office. We decided we were going to focus on the 23rd because it was the most egregious with the most death threats, and the specific discussion with the FBI was that we would focus on those, get those arrest warrants, get arrests taken care of, and then we would go back to the other most important ones, arrest cases, and continue on from that point.
Okay. Thanks for the explanation. So just so we're very clear about it, the reason that you guys are keeping this property that was seized on June 18th is not because you have to prove that Mr. Bailey blocked a doorway. If that were the only thing going on here, you would have returned that property to everybody. True?
We would have, not true.
Okay. Let me just make sure that I understand your testimony. Let's forget about this cabal, and let's forget about the conspiracy and the riots and Jesus Padilla and all of the riots that have been happening. And all the phone calls that you've been getting when we talk over each other, the transcript doesn't come up. So let's forget about all that for a minute. If these people blocking the doorway on June 18th were completely unaffiliated with them, completely unaffiliated with that anarchist group, by now they would have had their property returned to them. True?
If we seized an
Can you
item...
answer yes or no first and then explain?
No.
Okay, so you're saying that regardless of the fact that they're a part of this cabal, based on the crime that took place on June 18th, you still would have seized those 11 items. True?
Correct.
Thank you. Now let's continue moving on, and there's a page which on mine is 46-4, page 6 of 8. Can you turn to this part, please? Where it starts supplement and all caps lock.
Okay, 46-4. What page are we on?
I want to make sure that it's the same one that we were working on before. So.
Good.
We're on page 49-3,
Oh, okay.
page 13 of 15.
Okay, 49-3. Incident report.
Where it says supplement, and then on the left it says note, and it turns to all capital letters. See that?
Yes.
Okay, hold on. I'm not Chief Salvaggio. So in the bottom right corner of this document, it says page whatever of 15.
13 and 15.
Thank you, sir.
Yes, sir.
And we see that AP1 and SP1 were originally arrested, right? You see that?
Yes, sir.
And SP1's charges were rejected, right?
Correct.
By the magistrate.
Correct.
Why were they rejected by the magistrate?
I can't speak for the magistrate, but I'll tell you that it happens quite often. Either the stuff that we submitted was not enough, and we need to go back and submit more.
Right.
You'd have to ask the actual magistrate. It's very common. We follow up and refile those cases.
And if it's true to say that at that point in time, the only thing that you were able to submit was what truthfully happened, right?
Absolutely.
And the magistrate rejected the charge, right?
I don't know why the magistrate rejected it.
Okay. And then James Allen Springer, this name is going to come up when we talk about the June 23rd incident. He was arrested on June 18th.
Yes, sir.
And that case was rejected.
Yes, sir.
And that probably,
And refiled.
when was it refiled?
The case was refiled. I can't remember the exact date. I know it was sometime in early July.
Is there a criminal case pending right now?
Absolutely, there is.
So after we filed this lawsuit, that's when he was recharged?
No.
It was before we filed the lawsuit on July 4th?
I can't remember the date that it was filed, but it was filed because it was always intended to be refiled because of his criminal activity that are occurring.
And James Meade was arrested as well, right?
Yes, sir.
And what was his crime? I'll read it from your report, failure from your officer's report. Failure to ID as a witness. You see that?
You mixed up the papers.
I apologize.
Just a heads up here, we've got about 15 minutes until we're going to take a break. So.
What I plan on doing is getting through June 18th, and then we can break for lunch. Yeah, so let's move on.
I think this is on page 13 of 15, under suspects. Kind of in the middle, bottom part, bottom third.
Correct.
Okay.
And James Meade was detained for failure to ID as a witness, right?
Correct.
And then his property was seized, right?
Correct.
And why was his property seized? Because what?
For one, he's already suspects in other crimes. The property was received as evidence of the group's activity, the destruction, and the actual arrest that was made at that point.
James Meade is a suspect in other crimes. What other crimes?
If he was there as part of that, in that hallway, in that foyer, and I'd have to look at the report or whatever, then yes, he has additional charges. If he wasn't in there in that lobbyway, then he's not. So there's just so many, and I wasn't there. I don't know who this James Meade is.
But he was detained for failure to ID as a witness. You see that?
They did detain him, so they could ID him.
For failure to ID as a witness, that's why he was detained.
Yes, sir, I understand you.
Are you aware that it's not illegal in Texas to fail to ID as a witness, or do you not know that?
No, I'm not aware of that. That's not the practice that we've always done, nor is it what the district attorney advised us before any of these arrests were made.
The Leon Valley Police has a practice to detain people who fail to identify as a witness to a crime?
If they're an important part of this, and I'll tell you, Your Honor, I've never seen any witness that refused to identify a crime. We've had a few that, when my 28 plus years with San Antonio Police Department, that did, but they always eventually identified. So yes, they would be detained regardless.
Probably because you threatened to arrest them for failure to ID as a witness, right?
I can't tell you what they were thinking.
Right.
But we definitely would detain them.
Threatening to arrest somebody is a good way to get them to do something, right?
I've never tried that, but sure.
Right. So in Texas, there's two types of failure to identify that's considered criminal. One is if you're being arrested
Correct.
and you don't give your name. So if you're under arrest for doing something and the officer says, "What's your name?" and you refuse to identify yourself, that's a crime. True.
That's true.
Another way to commit this offense is if you're a witness to a crime and the officer comes over to you and says, "What's your name?" and you lie. Right? That's the other way to commit this crime, right?
But then, as far as I know,
Yes or no? Please.
No.
Okay. So it's your understanding that if you see somebody be a witness to a crime, you're allowed to go over to that person under Texas law and say, "Sir, what's your name?" And if they refuse to answer, you're allowed to arrest them for this crime of failure to identify.
that's not what I'm saying.
Please explain it.
So what I'm saying is these people are not just witnesses, they're parties to the offense. We have death threats going on, we have all these issues going on, and we need to identify who these people are that are specifically involved in that area where the crime has been committed.
So they're suspects.
There eventually are, yes, absolutely.
Not eventually. When James Meade was detained, was he detained in handcuffs, by the way?
I couldn't tell you, sir.
Why don't you look at the report or whatever? Tell me.
I'm looking at the report that talks about James Meade.
Okay, fine. So he was
It doesn't
detained.
say
Chief, what's the heading there? It says
SP suspect. SP2, he's a suspect.
So when he was detained, he was being detained as a suspect, not as a witness. Is that your testimony?
Well, in looking at this right here, it says that he was reportedly videotaped above arrest and detained for failure to identify as a witness, subsequently released after providing identification.
Right.
He was detained, yes, sir.
So I can read that also. I'm asking you why he was detained. Was he detained because he's a part of this cabal, or because he was a witness who refused to identify himself? Which one?
First of all,
Can you answer the question first?
sure, well, I need some clarification from you.
Ask me what.
So first of all, I'm not really smart enough to understand what a cabal is, so could you help me out with that term?
Well, your attorney can clear that up. It was in his briefing. It's a group of zealot anarchists.
Oh yeah, and it's a cabal. The individual here that was in there was part of that group, but there was another 15 or 20 that we never ever attempted to take their phone because they were not involved in the criminal activity that these were involved in.
What criminal activity?
In the blocking of the passageway, an intentional act that was going on at that time after they had been warned a total of 4 times about blocking the passageway of the door and of the street they continue to block.
So only David Bailey has that charge pending. James Mead was never charged with blocking the doorway, was he? Yes or no?
Not yet.
Not yet? And you're smiling. Is he going to be charged soon?
With the evidence that we believe are on those cameras, you bet, we need that evidence on there, which we're going to show that there's a conspiracy. It was a direct act on all of their part, and if we have it, he's going to be filed on with everybody else. It was in that little hallway.
He's going to be charged with a misdemeanor of blocking the doorway.
And others.
What others?
I told you before on the riot, that also shows.
Okay, right. Okay, so you keep referring to this riot, this conspiracy, but the report only refers to specific criminal activity. Wait, you need to not interrupt. What I'm asking you about is the specific criminal activity that your officers and you claim was taking place on 3 specific days. Now, on June 18th, when James Mead was detained, was he detained because he was a possible suspect in the crime of blocking a doorway? That's A. B, because he was a possible suspect in the cabal, the rioting anarchist cabal. Or C, because he was a witness to David Bailey's crime. Which one is the reason he was detained? And if there's multiple answers, you can tell me multiple.
There's multiple.
Okay, tell me why it is that he was detained on June 18th.
As part of this report, which this report is written to specifically for the arrest of David Bailey, this report only reflects the investigation of Springer, shows them as witnesses or SPs. So for this report, this specific report is only germane to the arrest of David Bailey for the offense of obstruction. Now, in the future, and what our plans were already, and have been already previously discussed with the DA, there are and probably will be criminal charges coming out, additional charges coming out for misdemeanors, and on this one, I think they're just misdemeanors, but on the other one, there is a lot more felony cases coming out for arrests.
You're talking about felonies of retaliation charges?
No, there's more than that. And there's federal charges that have already been filed and people have been picked up, and there's more charges to be filed, federal and local and state charges that will be filed.
You've seen these reports, these charges?
Have I seen which ones?
The ones that you just talked about.
I have not seen the ones where the FBI got the 2 warrants and ended up having to shoot one of the guys in a shootout.
That wasn't one of the plaintiffs?
It's not one of yours.
Was that guy, was he there on June 14th, 18th, or 23rd?
That's a good question. There's a lot of people who don't know who were there.
That person, those 2 people that you just, because you like to group everybody together. They were blocking the door.
This is a group.
You need to not interrupt, okay? You like to group everybody together.
Right.
And say they and this group and the anarchists, and that's how you like to present everybody, okay? So the 2 people that you just said with the FBI, with the shooting, were those 2 people identified anywhere in the June 14th, 18th, or 23rd reports, yes or no?
And the answer was already, you know, sir.
Okay. The answer was no, right? I wasn't sure if you said no, sir, or you know, sir.
The answer for the 3rd time, sir, is no.
Excellent. Okay.
I don't know whether they were there.
Now, but they're not identified in the reports. I didn't ask you if you know if they were there. I asked you if they were identified in the reports.
Not that I know of, sir.
But let me ask you, is it fair to group every police officer in the country together and say police?
We all have, if we have the same title, we're all police here.
Okay, but is it fair to say, let's say there's one dirty cop somewhere in Oklahoma. Is it fair to say that all cops are like that because they're part of this group of police?
Absolutely not.
Okay, so if those 2 people who got into the shootout, let's say those were really bad guys. I don't know who they are, but let's just say they're really bad guys. What does that have to do with Russell Zinter? Anything?
Absolutely.
What? Because they both like to protest police?
No.
So tell me the relationship you know exists between Russell Zinter and those 2 people.
I can't tell you that Russell Zinter and those 2 people have a relationship, but...
How about James Mead? Does he have a relationship with that?
Objection. He was trying to answer the question. I think
It's a yes or no.
Okay, guys, let's just take a breath.
Okay.
We don't need to argue with each other. We don't need to argue with the witness. Let's just keep our cool and ask a question, and he's been doing a good job of giving you answers. Let's just carry on that way.
Does James Mead have anything to do with those people?
I don't know, sir.
Okay. Does Brandon Pierce have anything to do with those people?
I won't know that until we get the evidence off their phones, sir.
Okay. So right now, you don't know if they have anything to do with them any more than me, the 2 marshals sitting at the table, or the judge sitting in the judge's chair, right?
No, I
Okay,
know
so
you
maybe
know.
we should take all of our phones and look at all of our phones, and maybe there's going to be a relationship between us and those two people.
I'm sorry, Your Honor, let the witness finish answering.
Yeah, we almost done here. We're a couple minutes before our break.
Couple minutes before the break. Do you have any evidence at all that there is in fact this cabal, this
Absolutely.
group, this group, and that every time there's a group of agitators, as you call them, outside of the police station, they're all part of the same group?
Yes, sir, they are.
What evidence do you have that every time there's a protest outside of your station, that it's all the same group and not just somebody who happens to believe in the First Amendment who found out that it was taking place and showed up?
So, to answer the question, you asked several questions. Can you repeat what actually your question is?
Yeah. How do you know, you said before a minute ago, that when there's a protest going on outside of the police station that they're all part of the same group? Remember you said that?
This group that are your defendants, we know are connected, and we have video of them together, we have pictures of them together. We know they're a connected group, and the pre-planning of most of their activities is online, or was. They've taken it all down once the rest were made, which is why we need the evidence on the phones. So yes, we have a lot of evidence that shows the connectivity of this entire group that we're talking about. Could there be people coming in and out of that group? Yeah, there could be. Absolutely.
And this group does what? Tell me, don't say what their goals are. Tell me the specific things that this group does.
They commit criminal acts.
Okay. Again, we'll try to be a little bit specific. They protest police,
They do protest police.
They protest in front of your station.
Yes, sir, they do.
People who you don't know if they're related or not have called. You said you've received hundreds of calls, right?
No, sir, we received thousands
Okay,
of calls
thousands
and
of calls.
hundreds of death threats.
How many of those death threats came from the 11 plaintiffs that are listed in this case?
I would love to know that answer, but I won't know it until I get their phones, Your Honor.
Well, doesn't the police station have phone records of who's calling you?
The police station has phone records, but most of the time they go as private, or they have the ability to spoof the numbers with an app, which will come out as a different number, and the only way to know whether those people sitting over there are the people making the death threats is to get in their phones and get the YouTube accounts and see if they're the ones that were out there actively threatening us, and some of them with guns.
So then, if I understand what you're saying correctly, you need all the items that were seized on the 14th, the 18th, and the 23rd to be able to get in there and see if they participated in these threats and these riots, right?
At this point, on the ones that we've submitted so far, it's specifically, we've got those evidence, and we specifically submitted it for the evidence based on the crimes that were going on, the threats and all that. When we finally are able to actually file for the rest of the phones, we'll make that determination on what crimes we're looking at on those phones at that time, based on all the evidence, and that's what we'll ask the judge to sign.
Okay, so you right now have, just take an example, you have James Mead's phone, correct? I'll tell you what, let's say Russell Center, because it explicitly said, well, it says it for Mead also, but for Russell Center, phone camera used to record incident seized. Right?
Which page are you on, sir, my note?
The same page that we were on before when we were reading about James Mead.
Which was page what?
I think for you it was page 13.
13 to 15, the next heading. So we were in suspects. Now we're going down one to witnesses. W1, Mr. Russell.
See Russell Center? W1.
Yes, sir.
Phone camera used to record incidents seized.
Yes, sir.
Okay, so what you guys need to do is you need to look at the thousands of death threats that you have and see if they came from this phone number, right?
That's just one of the things that we'll look at once we get on that phone.
And the other things that you're going to look at?
I'm
And
sorry.
the other things that you're going to look at on Russell Center's phone are what? You're going to look at his pictures?
We're going to look at the video, the original video of the arrest, and any pre-planning that occurred during that time period of the arrest.
What if he has 100 videos on his phone? You're going to watch all of them?
If they have any inclination that they're from that incident, then absolutely we'll watch all of them.
How are you going to know before you watch them?
They should be dated. They should show on
Let
them.
me ask you this. When you get a warrant, you're going to ask to be able to see the entire contents of the phone, right?
Yes, sir.
And Judge Jefferson Moore, who's signed dozens of warrants in this case, in the span of less than an hour, is probably going to sign them, right?
I couldn't speculate, sir.
Well, when you, let's say you're looking at Russell Zinter's phone, who's listed in your report as a witness, you're going to look at all the pictures, all the videos, all the text messages, all the emails, all the WhatsApps, everything there to look for evidence of this criminal activity, right?
I don't even understand some of those things you're asking about, first of all.
What kind of phone?
What's that? And
Let me ask you, what kind of phone? iPhone?
I don't know.
Okay, so you know. So you probably have email and text messages.
Maybe no text messages.
You might even have some banking records on your phone, right?
No.
No?
Don't be silly.
All right, well, I mean, you know, there's a lot of apps on phones nowadays for all kinds of personal information, right?
I don't use them, but yes, there are.
A lot of people do, though. In fact, cell phones by and large contain the privacies of life, don't they?
Can you describe what you mean by privacy of life?
You know, just in general, the general idea that they contain all kinds of private things. In your
Yes,
life.
sir.
Okay, and if you're going to gain access to Russell Zinter's phone that's listed in your report as a witness, based on the fact that you believe that he's a part of this cabal, you're therefore going to gain access to every text message, every email, every phone call, every incoming and outgoing call, every voicemail that's still on the phone. Do you know what WhatsApp is? Have you heard of WhatsApp?
No, sir.
Other potential messaging apps, you're going to have access to every single thing he ever sent on that phone, right?
I have no idea. Well, I'm trying to answer you. You keep interrupting me.
If you get a warrant for his phone,
Right.
you guys are going to look at everything, right?
We're going to look at whatever we ask for on that warrant. Absolutely.
And to date, you haven't submitted a single warrant for the June 18th incident.
Not that I know of, sir.
All right, I think we can break for lunch and pick up after lunch if you want.
Okay. Thank you for that. Chief Salvaggio, do you know how much information or what information is on any of these cell phones for which you have not yet received search warrants?
No, sir. We have no way of knowing.
Okay. Thank you.
And I can tell you, all of them are locked that I know of, and the only way to get into them is for somebody with the right machinery to do that, and we do not possess that window.
Okay. Thank you. All right. You may step down for now. You may have to come back up later. We'll go on a break. We'll come back at 1 o'clock.
Thank you.
And we'll resume then. Okay?
Just a reminder about the sequestration, not to talk to Terry Brooks and any other witnesses
Yes.
who are not parties.
Right. We've agreed that we're not going to have discussions between and among with non-party witnesses. So let's make sure we adhere to that. Thank you.
All rise. All rise.
Please be seated. Okay, we're back on the record again after our lunch break in SA18CB00680-FB Zinter versus Salvaggio. Mr. Radner, would you like to continue?
Yes, thank you. I'd like to tie up some loose ends before we move on to the June 23rd incident. First things first, you testified earlier that you watched some videos of some of the events that we talked about earlier today. I just want to clarify that was not police body cam video, right?
No, a lot of it was police body cam.
But you also saw video that was not police body cam video.
Correct.
And you saw that, was it presented to you as a video? Is it a file that's saved somewhere? Is it a YouTube link? Where could I find that video?
Depends on what video you're talking about, sir. There's numerous videos. One of the things that we have to do if we really want to save those videos is to download them as quick as possible. A lot of times we didn't have time to do that, and we lost them because they have the ability to take them down, delete them, so that we have no way of seeing them. So I don't know which video has been deleted already, which is truly why we need into those accounts so that we have all the documents so we can review all of them from all angles.
So if I understand it, what you need from YouTube are videos.
Yeah, no, that's one of the things. Yes, sir.
Okay.
Absolutely.
Right, I know. You'll also need every email that was ever written, but we'll
That's
get
not what we said. That's what you said.
That's not in the affidavit.
He asked me what I said. I've never said I need every email that they've ever written. I've never said that.
Are you familiar with the warrants and the affidavits that Terry Brooks was responsible for?
Yes, sir, I am.
And you saw that one of the things he requested was every single email ever sent or received, right?
Yes, but the preservation order that we gave on the 23rd and 24th specifies a time period from May 2nd all the way to June 23rd. That's really the only time period we're looking for, and YouTube understands that.
Oh, I understand. Okay.
Yes.
All right, we'll get to that soon. Now, you testified in general about that this is clearly not just about the lording over the officers that Mark Brown is charged with on June 14th, the blocking the doorway that David Bailey was charged with on June 18th, and, well, that's all we talked about so far. You said that that there's this conspiracy, you used the word riot, so there's this larger criminal scheme that you're investigating. Is that fair?
That's very fair.
Okay. Now, this larger conspiracy that you're investigating, it's a conspiracy to do what? To do what specific crime?
So, Your Honor, and I'll answer the question, and I'll follow that, but tipping our hand to the criminal investigations of the future that we're working on really has nothing to do with what we're here for today. I'll answer the question, but I think it's an unfair thing to do to tell them exactly the criminal investigations that are forthcoming and the felony and federal charges, state and federal charges that are forthcoming on every one of those individuals. I'll answer if you want to, but I believe that this is a gross miscarriage of justice here for them to get the free hand and free look at the investigations we're doing. I'll answer for you if you want.
Yeah, I'd like an answer.
Okay. Organized crime absolutely is being considered. We talked about it a month and a half prior to the actual arrest with the DA's office, the AUSA, and the FBI. And we also are looking at, on the 18th, we're looking at the violation of riot as well. With that group who were there, it also shows as part of the evidence that they were also involved in organized crime, and they will be brought into the organized crime statute as well.
Is this a Texas organized crime statute or a
State and federal.
So, but you guys are investigating the state.
We're turning over evidence on a daily basis to the federal government. Some charges have already been filed. There'll be a lot more coming, sir.
Charges have been filed against my 11 plaintiffs?
I don't know what the AUSA and the FBI have taken forward against who. I don't know. As we get something, we turn it over to them. They are taking it from there, and we're not really privy to the investigation and where they're at with anything. So
you don't know if people have been charged?
No, I know that 2 people have been charged. I was contacted about one of them that had the death threats on me last week. The Joint Terrorism Task Force contacted me, and they've tracked him to Arkansas, and actually even looking Kansas, Arkansas, involved in a shooting with him where he fired on the FBI agents, and they shot him several times.
And you were able to track this person to Arkansas?
I was, FBI.
FBI did, based on a comment that this person made, or what? What specifically did this person give you that you were able to give to the FBI?
I haven't seen it. The death threats that came on me, they notified, another Joint Terrorism Task Force notified us and the FBI local Joint Terrorism Task Force, and would let me know that they were getting warrants on a individual. I can't even tell you his name, to be honest with you.
Okay, not one of the plaintiffs in this case?
No.
Okay.
To the extent this line of questioning continues, it among other things, is heightening concerns regarding younger abstention. You may want to shift your focus. I don't think you need to get into the details of ongoing federal and state criminal investigations to get at what you're looking for. I would suggest that if we keep going down that line, I'm going to shut it down. And it's going to start to look like this whole thing is intertwined with ongoing criminal prosecutions, and that's right in the squarely in the younger abstention.
So I'll tell the court what I'm doing right now. There were specific items that were seized from specific people on June 14th, June 18th, and June 23rd. Those items are being kept based based on the papers that have been filed by the defense counsel in this case because of ongoing criminal investigations. I want to know why the property in this case, I don't care about what happened in Arkansas. I want to know about the property in this case that was seized and what alleged criminal conspiracy is taking place that involves my 11 plaintiffs. That's what I'm getting at.
You've asked a number of times and received answers, I think, that reflect, at least in this witness's view, that those items were seized for several reasons, one of which was that they contained evidence of the charged crime. The other was that perhaps also they contained other matters. But what you haven't elicited from this witness is that they were only seized because they contained evidence of some other charged activity. You tried to get him to say that a number of times. He hasn't. So, is there anything else to be gained by just repeating the question?
I think there might be. I think there might be.
Okay,
I'll continue for a couple minutes.
Sure, I'm just listening very carefully.
If you have to shut it down, we'll shut it down.
Okay, I wouldn't have interjected like that unless my temperature were starting to rise.
Understandable. Okay, so the criminal conspiracy from June 18th was a riot, right?
The criminal conspiracy from June 18th includes the additional people who are in that area and their ability to also be charged with the obstruction. There was more than one person in that hallway. If there's one person, it'd be different. But when you have 4 or 5, how many were in there, they also can be a party to that obstruction. And if we find evidence of that, they will be charged with that crime. But they will also be charged with the crime of riot if we show that they alone, and this group alone, were causing a substantial disruption of our activity with 7 more people, which anybody you bring on the stand is going to tell you what it's done to our entire, not only police operation, but city operation, that we've had a substantial disruption because of the thousands of calls, the hundreds of death threats, the continued abuse, all the way through to last night of my family. So yes, there are additional charges that we are planning on every one of those people that are sitting behind you, including the ones that are not your defendants yet.
Okay. Now, those thousands of calls and hundreds of death threats that you just referred to, how many of them came from my 11 clients?
I would need to have the evidence that we've asked for, Your Honor, to be able to definitively tell you which ones came from them.
Okay, so the answer is you don't know.
No, I just answered you. I didn't say I don't know. I said I can't answer a question that I can't see yet.
So let me ask the question again. Which of the 11 plaintiffs in this case threatened your family?
Val, sitting there.
Val's not a plaintiff.
Jack Miller, sitting there.
Jack Miller
has on his site, which we will be filing felony charges on him as well. Springer also has a felony charge. We have multiple felony charges, additional felony charges coming on Springer. So the rest of them, it depends on the evidence that comes in and what we're able to show.
Jack Miller threatened your family?
Jack Miller posted stuff, and he even made a video about why he can post stuff and what he thinks that they need to do to continue with that activity. He intentionally and willfully posted that online, and he intentionally and willfully put my family's danger out there, and he's the one that posted it, him and him alone.
When did you post this?
I'd have to go get the video for you, sir. I wasn't prepared to actually bring this into evidence today because it really is tipping our hand as to what we're doing in our investigations.
What's preventing you from getting this?
What's preventing me now, sir?
Is getting the original evidence.
All of this disruption of our ability to get the evidence, the live evidence, some of the stuff that Jack had put online has been deleted. He also normally doesn't go live, so anything he puts online is normally cut, so you don't get any original evidence. And I would not feel comfortable going to a judge and asking for a warrant without the original evidence that can be found through the YouTube warrants and the evidence that would be on his phone that might show that the conspiracy for the other felonies that we're alleging exists. So this is 100% impeding our ability. We've not been able to touch phones that we seized from him on the original warrant, which was back in May or June, because of the overly broad request for all cameras and all videos for all these defendants. He didn't name the incident that happened back in May or June, whatever it was. But based on the overly broad, our attorneys have asked us not to touch his evidence of his crime that he's already had a criminal charge on.
So when you say this, you mean the activities of these individuals, or this lawsuit? Or
the lawsuit has stopped us. We would have had the phones back to the witnesses by now if the lawsuit wouldn't have stopped us. So we are 100% stopped in our criminal investigation on all of these individuals until we, at such time that we get the rest of the evidence that we need to go forward with.
Okay. Well, except that not a single warrant request was submitted as of the date that Brandon Ramsey signed that affidavit, assuming you're being truthful, on anything from June 14th or June 18th, right?
I think I've already testified that no warrant has been for either one of those things.
So
we have a warrant for on Jack Miller's stuff, and we've already served that.
Right, but then a minute later, you just a minute ago said that by now their phones would have been returned to them. You had those phones for over a month, maybe more like 2 months, without submitting a single warrant request on any phone that was seized on June 14th or June 18th. How do you reconcile those two statements?
I'll reconcile it by saying, sir, you filed your motion 2 weeks after we were filing the criminal charges that we had at hand, the arrest charges, and if you know anything about our state law here, you have to get the arrest charges out. You filed this on July 3rd when you filed your paperwork, and from that point on, which is only 2 weeks previous from the incident, the first or the second incident, 1 week from the other incident, we have not been able to request any warrant, nor have we requested to see any of the evidence or gone through any of the evidence that we have in hand. So yes, we filed a whole bunch for the 23rd, and that was a planned effort between us and the DA's office on which evidence they wanted to see first. And we are going down that road, and we will file as long as we get the evidence, or the evidence, the court order gets lifted and allows us to file for more warrants on the individuals on the 18th and the 23rd.
Which court order is that?
This right here, the temporary, the TRO that was first filed, and then the subsequent extension of the TRO, and then once that died, the TRO died, we knew already, it was notified to my attorney, and my attorney asked us, do not take any action, don't touch anything, we don't want to look at anything in case the judge feels like it's inappropriate, we don't want to do anything until this TRO, or the impending temporary injunction is filed. We don't want you to touch anything. And we have been stopped from June 3rd till now from any further investigation on these individuals.
Your testimony is that no warrants were submitted after July 3rd?
No.
You just said?
The warrants for, as far as I know, the warrants weren't submitted. The evidence wasn't touched. No, I'm sorry, you're right. It's not after July 3rd. It's once the TRO was signed. From that point on, I can't remember the exact date. So we did submit the warrants for the 23rd, but we have not submitted the rest of the warrants. So you're correct.
So that's why when I'm getting in here, that before you said that no warrants were requested once we filed this case on July 3rd, and that's been impeding your ability to do law enforcement work.
Right.
But that's not the case, right? Because there was no TRO on July 3rd. Do you know when the TRO was entered?
Actually, no, because we never got served notice of it. We didn't have any idea of the actual TRO.
Do you know what month it was entered?
As far as I know, it was July 3rd.
The TRO.
The TRO, or are you talking about y'all's lawsuit?
No, not the lawsuit.
Okay, I'm sorry. As far as I know, the lawsuit was filed on the 3rd, and the TRO was filed sometime later, whatever that point is. We have not gotten search warrants after that period. We've been focusing on the case on the 23rd, and would have by now backed into the 18th and backed into the 14th if we were not being impeded.
Right. Now, the TRO was entered on August 20th. So you're saying that as of August 20th, your ability to conduct this investigation has been impeded?
Absolutely.
Okay. From June 14th, when Mark Brown's property was seized, and June 18th, when other people's property was seized, nothing prevented you from submitting a warrant to be able to search that property all the way up until August 20th.
That's not true, not true.
What was stopping you from submitting a warrant between June 14th and August 20th when the TRO was entered?
It was the constant and daily bombardment from the group for 11 days, all the way through to the 23rd, and the continuing constant bombardment with open records requests, with the arrests that we have. We have a very small department, and this is why this group picks on those small departments. We have a very small department and only have a few detectives. And we can only, when we're talking about arrest on the 23rd of this many people and pending investigation and everything we have to do, that arrest case has to go before the other cases because it's a felony. And we only have 21 days to submit that to the DA's office. So that was our focus and continue to be our focus.
Now, the crimes that you're alleging took place on June 14th, 18th, and June 23rd are very, very serious, aren't they?
Absolutely.
Okay. Now, in fact, your department has submitted dozens of warrants based on at least what took place on June 23rd, right?
Correct.
And it's your position that June 14th, June 18th, and June 23rd are all interrelated, true?
Absolutely.
Okay, now if that's the case, what I'm trying to get at here is that, see, our position is that the reason the property is not being returned and the reason that the department is doubling down on this criminal investigation from June 14th and 18th and 23rd is in response to this lawsuit and because you don't like the fact that they protest, okay? What I'm trying to get at here is what stopped you from June 14th until August 7th. August 7th is when Terry Brooks submitted dozens of warrants to Judge Jefferson Moore. Why didn't he include warrants for the property that was seized on June 14th and June 18th at that time?
Objection, Your Honor, that's been asked and answered a number of times by the Chief's office.
I don't remember hearing an answer to that question at all. And that's the first time I asked that question.
Okay, why don't you answer that question?
The continued and constant bombardment of the phone calls, the arrests that we continue to have to deal with, the plethora of hundreds of open records requests that these guys file, which now ties up my officers, my detectives, and myself of having to go and get every single item. We're talking thousands and thousands of items that were requested by members of this group, including the guys that are sitting over there. So it is a tactic to stall, it's a tactic to delay, and 100% has impeded our ability to continue with the investigation. We had to focus on the felony investigation or the felony charges that we had 21 days to submit, and we had to focus on getting the arrest warrants and search warrants for YouTube and Google and all that other stuff we had to do. So if you're saying that this has anything to do with y'all filing, that's a nice made-up story that you have there, sir, but it's 100% not correct.
So there was enough time for Terry Brooks to submit dozens of warrants on August 7th. Are you aware of that?
There was enough time to submit dozens of warrants on August 7th for the incident that occurred on the 23rd of June.
Right. Now, if they're all interconnected, in fact, we're going to go through these soon, but these affidavits are identical in large part. The only thing that's different is the name and the item. Why couldn't, and I understand you guys were bombarded, but the same way Terry Brooks had enough time to submit all these warrants about the property that was taken on June 23rd, why didn't he also have time to just print out an extra couple copies and include the property from June 14th and June 18th? What's the difference between, and I understand the bombardment, that's what he keeps talking about, Your Honor, he keeps talking about the bombardment. Why is only the property that was taken on June 23rd, did he have enough time to submit dozens of warrants on that and not a single warrant on anything seized on June 14th or June 18th? That's the question, and I'd like him to be able to clarify.
Why don't you clarify it? It's a pretty long question. Why don't you restate it? Let's see if it's appropriate. State it
My
again.
objection is, Your Honor, he has answered this question at least 4 times.
Yeah, I think
He's answered it with non-responsive answers.
Well, let me hear the question again. I'm inclined to agree that you've asked him a number of times and he's just not giving you the answer you want, but that doesn't mean he has an answer.
Let me ask it this way. Did Terry Brooks have any time to submit any warrant requests after June 14th?
No.
Not even the dozens that he submitted on August 7th?
He had the time under the circumstances to do what he did and submit those warrants. Those are felony warrants, felony charges. We have 21 days. This misdemeanors are self-filing. We have a lot longer time period to deal with those cases, and we were going to look and deal with the first ones first, with the amount of personnel that I have, and the amount of him having to be the main one that actually pulls all the videos for the hundreds and hundreds of video requests that came in by this group. That has cost us, and half of them they don't even pick up. It's just a way to terrorize our city.
Your department has received thousands of phone calls, you said? Threatening phone calls?
Thousands upon thousands of phone calls.
Since May, June, since when?
Since the day of May 2nd, when Jesus Padilla was arrested, and all of the gentlemen began the campaign to come in here, as Jack Miller likes to put it, to be a police educator and teach us a lesson.
Thousands of threatening phone calls.
We have thousands of phone calls, hundreds and upon hundreds, I haven't counted them, that are threatening phone calls.
Are those recorded anywhere?
Some of them are recorded.
Why are only some of them recorded and some not?
Because some of them came through channels that are phones that are not recorded.
Whose phones?
City phones.
City phone?
We've identified the main ones where the threats were committed.
And you've pulled those recordings?
We have in possession of those recordings, and yes, we have recordings.
Great, okay. Now, so with these recorded phone calls and these threatening, you said these hundreds of threats that you've received, it's your position that those hundreds of threats that you've received, those people who threatened hundreds of times are a part of the same group as my 11 clients, right?
Absolutely they are, sir. Because every one of them are bringing up specific facts that were on your client's YouTube accounts, specific times, including one Monday after Jack Miller released the video that he released. Shortly afterwards, I got a threatening phone call to kill all of us and my family.
When something's posted on YouTube, you are aware that everybody can see it?
Absolutely.
Okay. Now, obviously, it's your position that anybody who made a call, threatening call, was a part of the same group. You've said that many times, right?
Yes, absolutely.
Okay, now, isn't it entirely possible that some crazy guy sitting in his basement somewhere in Alaska saw these videos and decided to call you guys up and threaten?
So that's why we need the evidence, sir, because there are a lot of crazy guys out there that actually want to do harm to police, and inciting them to do so with lies and with the way that they're posting this stuff, it is all connected. It is not an individual at this point that we're looking at.
But what my 11 clients are doing, according to you, is posting videos of interactions with the police.
No, they're posting videos, period. And some of them we don't even have interactions with bold-faced lies in them.
Okay. Posting videos of bold-faced lies.
Absolutely.
If you're allowed to lie, aren't you?
Sure, you can do that. But that's that lone crazy guy in his underwear in Alaska in the basement that you described,
Yeah.
That guy doesn't know lies from truth.
How do you know if that guy is a part of a group together with my 11 plaintiffs? In other words, what gives you the right to say that my 11 clients have anything to do with that guy in his underwear in Alaska?
I would say that 100% that anybody that calls us and references one of these individuals and references all the bad stuff that government is doing and why judges are so corrupt and police or this and that is part of this group. So.
Okay, but short of that, the only connection that I'm hearing is my clients posted something on YouTube, somebody makes a phone call, you draw the connection, there must be some sort of relationship here.
And we'd really like to get all those evidence that we have so we can show that connection, sir.
I just want to make sure that I understand this very clearly.
You asked me, I think it's painfully clear to everybody. I think we got it.
You don't think that my 11 plaintiffs are telling that guy in Alaska to make threatening calls?
Oh, I think they are. I think everything they're doing is inciting them and encouraging them to make phone calls. In fact, multiple of them, including the ones that are sitting in this room, have called for those phone calls. They call it call flooding. And they intentionally tell them to call now and put the phone number out. So it can give our names, our family's information. Absolutely. Your client.
My clients gave out your family's information?
Absolutely.
Which client?
Absolutely. Val and Springer posted that
Val is
evidence.
not my client.
Okay. Well,
Which one of the 11 plaintiffs in this case
Right.
put any information about your personal family?
I'm going to get fed up soon if you continue arguing with the witness. Ask him to elicit evidence that supports your request for preliminary injunction.
Fine.
Okay? and that's it. You don't need to sit here and argue with him for 3 hours. Okay, I've been extremely lenient because I want to give you your chance. And I want to make sure that everybody feels like this is a neutral, fair opportunity to present their case. I'm going to do that for the other side as well. But what I'm not going to permit is incivility or arguing with the witness. Okay? Dial it back.
Fine. Are you aware that Bao is not one of the plaintiffs in this case?
I'm aware that he's currently not one of the plaintiffs in this case.
Excellent. Which plaintiff has posted anything online about your family?
Val, I'm sorry, my bad. He is in the room. I keep seeing him back there smiling. Springer, James Springer did. Jack Miller has multiple occasions, and then called for a call flood so that everybody can check his videos and call about my address and phone number. He urges people to go out there and find it on his YouTube and to present that. There's another individual who goes by Furry Potato, Zoe, I believe. Zoe Pettis. It's a fake name too. We're still trying to identify that person, which is another reason we need the evidence that released it as well.
I have over here every single threat that I was given by your attorneys. A lot of them are 48-5. I have the 3 additional packets that were given to me today. I'm going to approach you, I'm going to hand this to you. I'm going to ask you to, as you go through them, make a fold in the bottom right corner like this. Anywhere where, or better yet, let me give you a pen. Circle all the ones where Jack Miller or James Springer threatened your family.
And that's if it shows the actual person. We'd have to look at that too.
I'm sorry, what did you tender the witness? Just the warrants or
The social media addresses that were posted on cases. And the ones that you needed.
Okay, so the ones that you don't have to have.
You don't have
So I gave you some, here's some others.
One is posted on our motion, which is docket 48.
Yeah, so the witness is looking at docket 48, exhibit E.
And just for the record, these are all the threats that I was given. Some were you filed on PACER, and some were given me today by defense counsel. I gave you all the threats I have, and I want to identify the ones.
Could there be other threats?
Yeah, before that, you make it sound like these are all the threats. That was a representative. Our exhibit E was a representative sample of the threats that had been received.
Okay, well, simply, these are all the threats that I've been given. These are all the ones that were produced pursuant to the subpoenas. And
Okay,
and I'm
this.
asking him, based on his testimony, to circle the ones where Jack Miller or James Springer threatened his family.
Okay, and the result is going to be that some de minimis or zero set, de minimis number or zero set is produced from us sitting here while the witness flips through all these exhibits. What's the?
Well, I can give the spoiler. Say there aren't any.
Sure, go ahead. Let's do
There
that.
aren't any. But
Okay.
I need him to say that. I can't do it.
Great.
So what I want is...
Is it undisputed that there are no threats anywhere attributable to parties to the case?
I dispute that. Absolutely.
It's not undisputed. So.
Right. So
We're disputing
So what are we doing then?
We dispute that James Springer or Jack Miller ever threatened this officer's family.
Okay. And I think he's testified that he believes there is evidence or will be evidence that that did occur.
I'd
Right?
like to see that.
Yes, sir, absolutely.
Okay.
And you do have one in here that is representative from Springer's fireside chat with most of the individuals that were here that night. He didn't take it down. He should have never posted it. And I'll read it. Bring your sidearm for protection. Every American has a right to defend themselves. Let a tyrant cop get out of hand. Fear for your life and execute. The chief is already a marked man. He'll get what's coming to him. And then response below from somebody we can't identify. Leon Valley School will be in session tomorrow morning at 11 a.m. You have been put on notice.
Okay. Now, what is the name of the person, according to YouTube, who posted that?
I don't know
The
the
comment
name.
that you just read out loud.
Let me finish.
Let me ask a question.
You did ask a question. I
Your
answered.
Honor, I can't even understand the question.
I'm going to rephrase it in a way that makes perfect sense.
And,
All right.
and volume is a little bit loud. We can hear him perfectly fine without him
Okay. I'm going to ask the question that makes
Take a deep
perfect
breath.
sense.
Here we go.
Did James Springer post that? Yes or no?
Absolutely did.
He did.
Yes, sir, he did.
Did Jack Miller post that?
Not this one. In fact, I don't know if Jack Miller did or not because I don't have Jack Miller stuff.
So that post that you just read, where Sean R. is written as the author, was written by James Springer. That's your testimony, yes or no?
No.
Let me ask you again. You see Sean R. at the bottom as the person who wrote that comment that you just read.
Correct.
Okay. Your testimony, obviously, is that Sean R. is James Springer.
That's not what I said.
Okay.
You asked me if James Springer posted it, and I said, yes, he did post this. He posted the video that contains these things and is complicit in that threat by not taking it down or doing something about it.
So your testimony is that James Springer posted the video. Sean R. then made that posted comment, and you're attributing that to James Springer.
James Springer has the ability to remove that comment. His moderators have the ability to remove that comment, and he has the ability to not upload this comment and take it down immediately. He chose to not do those things, and what we believe, their moderators were removing pro-police comments and leaving death threats and our addresses up there for everybody to see. They had the ability, so it's on his YouTube account. YouTube says in 7B that them and them alone are only the ones responsible when they post this. So yes, James Springer is the person who posted this threat.
Okay, and I just want to make sure I understand that, because when I hear post, I'm thinking that Sean R. could be in Alaska in his underwear, right?
I'm sorry you're confused when you hear that.
Okay, let me clarify. I understand the distinction between somebody who puts a video and somebody else who comments on it.
Right.
I understand the distinction. I understand there are distinctions as a factual matter. I understand there may be distinctions as a legal matter as to who is responsible for posting or reposting or publishing. These are all legal concepts, and I understand that concept, and I understand the witness's position that, in his view, these things can be attributable to one person. I understand your view that they may not necessarily be attributable to a single person.
Okay.
Got it.
Excellent. Have you submitted a warrant for Sean R.? Name who's posted as the person who made that comment, yes or no?
Not yet. We don't know who Sean Yar is until we get your stuff that you're impeding us from getting.
Have you sent a warrant or a request of any sort to YouTube to find out who Sean R. is?
Again, no.
Okay.
We don't know who Sean R. is, and we would have to go through and get the IP address off of you guys, because they make fake accounts. We need the IP address off of that post to be able to identify who that person was so that we can follow that trail through to making arrests.
And the way that you're going to find Sean R.'s IP address is by getting James Springer's YouTube information?
Yes, sir. It posts the IP address on every comment that's made and creates a record, which is original evidence that we need to identify who's making those threats.
Can't you also just ask YouTube for Sean R.'s IP address?
Not that I know of.
You haven't tried it, though. You don't know who Sean R. is.
That's the point, sir.
Sean
You don't
R.
know who Sean R. is.
Sean R. may have nothing to do with these 11 plaintiffs, right?
Sean R. posted something that were death threats that your 11 plaintiffs, or at least one of them, posted when he had the ability to take it off.
I'll stipulate on the record that if they want to file a subpoena or some sort to find out who Sean R. is, I won't object in any way.
Yeah.
In fact, I think they should.
And we will.
And just for the record, what we've been referring to is document 48-5, page 10 of 13, where it begins bring your sidearm and it's signed Sean R.
Okay, thank you. I've got it here. Sorry, I said I have it up here. Anything further for this witness?
A little bit. The thousands of calls. Do you believe that there's any evidence on the items that were seized on June 14th, June 18th, or June 23rd that will identify those thousands of callers?
Yes, sir.
And can I just ask what that's based on, why you believe that?
There were people that were obviously at the scene that were sending, that had stuff live, that were making phone calls and from the scene and describing things. And we believe the people that were out there were part of the people that were calling in. We've got a video from James Springer himself saying that, for everybody to call, so he's instigating that call flood and urging everybody to call. And that one was on the 19th, because you got to remember, they were here 11 days doing this on a daily basis. And this 11 days, we were going through the phone calls, the threats, the emails, everything for 11 days.
So, last point. The items that were seized on June 14th, 18th, and 23rd. You need those items because you need to see if there's evidence of telling people to make death threats, conspiring to create a riot on June 18th, organized crime on June 23rd, and potentially blocking the doorway on June 18th.
And the actual offenses that occurred out there. Yes. There were many more offenses that were occurring. We were trying our best, Your Honor, not to make any arrests, but there were a lot of violations. Jack Miller came back on our property after being criminal trespass. We didn't make that arrest. That's on James Springer's video. We plan to file that charge as well. Several times, Val came back on the property. Several times, Jesus Padilla came back on the property. We could see some of that stuff, and now the videos are gone. We can't get access to them, so that's impeding our ability. It was things that we were watching, but they have the ability, like we talked about, of uploading it, not uploading it. So there are many, many more charges that we plan as part of our operation. We said, do not make arrests if you can keep from it. But when they get out of hand, we have to do something.
Or if they fail to identify as a witness. Okay. Let me ask you one other thing. What if I agree, stipulate to an order, subpoena to YouTube, that any of my clients' videos that they ever posted, you can have? Would that satisfy you?
It would satisfy part of what we're looking for. We would also need to be stipulated that any text messages, because we have them on video, urging people to text me, to call me, or also to email me, and their moderators put out their email addresses so that they can communicate with each other by email, by text messages. So it would have to include the emails and the text messages and the IP addresses of anybody that made a threat during that time period. So yes, we would be more than willing to allow them, like we told some of them that day, and we did. We've allowed some of them to open their phones, those that would cooperate, and let us get the videos off of them. These clients here refuse to do that. And if they would want to come open the phone and let us look through it, just like the other ones that did cooperate, we'd be more than happy to work something out with you.
So, but you also want to read all their messages and emails, right?
I want to read any message or email that is pertinent to the time period that the criminal activity has been going on.
Right, but without knowing, you don't know what's in the message until after you read it.
Correct.
So you want to read all their messages for that time period.
For that time period.
Whether it's to their wife, their girlfriend, their boyfriend, their lawyer, their doctor.
If their wife, like James Freeman's wife, is involved in this, absolutely, I want to read that.
Right, but you don't know that until you read it.
No, we know that she's involved in it. She's one of his moderators, and she's on every one of his videos.
So even if they would have come into the police station on that day, you said that if they would have let you look at the videos, you would have given them back their property. You just said that, right?
Not some of your people. Some of your people are arrested and we're going to jail.
Besides for the ones that were in charge.
The vast majority of them have charges. There's only 2 that don't have charges at this time. Really. So the vast majority of them have charges. So yes, if they were just a flat out witness, I can't remember the gentleman's name. I think he's one of your defendants, but I just don't know the gentleman that had the oxygen mask. We never even took his phone, never even looked at it because we felt he was not involved. There were plenty of people that we didn't take their phones that were out there protesting that were not involved in what we felt was a criminal activity, and we did not take their phones.
Right.
Well, look, how about this? What if we take a break for 5 minutes, unless this is, for rhetorical effect, I don't know. We can take a break for 5 minutes, and you can propose to counsel search terms, search parameters, a time frame, and see if there can be an agreement. If there can be, then maybe we don't need to keep spinning our wheels about a preliminary injunction. If we can't reach an agreement, that's fine. We can carry on. We only need to take 5 minutes. I could probably use a restroom break anyway. So why don't we do that? Is there anything else that you need to pursue with this witness before we do that? I mean, maybe it's just false hope for me. But what are your thoughts about that, Mr. Ryan?
We can take a break. I will tell you for the record, I have proposed to council that if these items are turned over to me, I can look them over, give them anything, just like when I want to subpoena their records or request their records, and I'm going to send lots of document requests in this case, they're going to be able to, on their own, with their lawyers, decide what to give me and what to object to. Obviously, with the privilege law, all I'm asking for is the same thing. And once I have them in my possession, I can assure you, as an officer of the court, I will not delete a single thing off of any one of those. But it just transfers the...
Well, keep in mind, we're kind of crossing, overlapping things here, right? What you've got to reach an agreement with is that we can agree within this civil action that there can be some kind of an agreement, maybe there can't be, with respect to the ongoing civil action and the request for injunctive relief from the court with respect to how certain matters might go in a state criminal proceeding. So it may not be possible to reach an agreement, but we have to keep these things separate. But if we can reach some kind of an agreement, then maybe we can avoid the need to come to a decision point pretty early on in terms of injunction. If we can't, that's fine. But it sounded like there might be some possibility to tailor some of these searches. If there's no agreement to that, then and it also may be that different situations or devices require slightly different treatment. If there's somebody who has an ongoing criminal proceeding, that's going to be a slightly different topic than somebody who has no ongoing criminal proceeding that maybe is just a witness.
Right. Yeah, that's certainly fair enough. And the concern that I have is that they want to read every single text message. That's what he just testified.
Well, there's a big distinction between narrowing the date range. That gets you a huge benefit in the eyes of the Fourth Amendment. Narrowing the scope of topics. There's just ways to tailor a search so that it's not broader than it needs to be. Sometimes they have to be fairly broad and there's no way to get around it. And sometimes they can be pretty targeted.
Yeah, and just for the record, and this I'm sure you've seen, the warrants that were actually given to Google have absolutely no date range.
Well,
what it says is any and all messages, comments sent or received by the individual account, and email content.
But again, I want to be very clear that I'm not at this point ruling on or putting any pressure on anybody with respect to how a state prosecution goes. I've made it pretty clear that I have concerns about federal court intervention into state ongoing criminal proceedings. I'm extremely concerned about that. I'm concerned about other stuff in this case too. But I'm concerned about that. I don't want to be seen as influencing that in any way at this juncture. I'm really just open to the possibility that you all can meet in the context of this civil proceeding and figure out something going forward. Maybe you can, maybe you can't. But why don't we just take 5 minutes and see if we can do that? Okay?
All right.
You may be seated. Thank you. Okay, once again, back on the record in SA 18CB 00680, Zinter versus Salvaggio. Okay, what do we get anywhere? I can see from that rueful smile, maybe not.
I always smile. Your Honor, as you predicted, it was wishful thinking.
Okay.
What I suggested was we do an attorney's eyes only review of the property that was taken, and then agree what should be shared with the defendants in this case and what should not be. And Mr. Frigerio suggested that that might be interfering with the prosecutor's office, and that therefore he can't agree to any such agreement.
I understand.
So,
thank you for trying. It is a, I don't know if it's unique, but it's an unusual situation.
certainly is. There's only a couple more things that I'm going to delve into with this witness, and then I'll be done probably in the next 10 minutes.
Okay, all right, yeah.
All right.
It's your time.
If I asked you to make a list of all the people who are in this conspiracy, this cabal, would you be able to come up with any more names than the people who were present at the police station on June 14th, June 18th, and June 23rd?
Yes, sir.
Okay, and where would you get those names from?
Intelligence has been gathered between law enforcement agencies and myself.
Okay, and that intelligence that has been gathered, does it create any sort of tie, any sort of connection between the other people who are not parties, who are not there on June 14th, 18th, or 23rd, and the people who are there?
Yes, sir.
Okay, and those ties would be what?
Those ties would be their joint working together collectively, collaboratively, oftentimes doing the visits and committing of the criminal crimes. Multiple of your defendants and others have been arrested in conjunction with each other, including and in conjunction with other people that are not your defendants as well. So yes, sir, there's a lot of collaboration between these groups, and they've been arrested multiple times together, singly, together, with all your defendants, with not some of your defendants. Absolutely, is a complete tie.
And in addition to the people who were there on June 14th, 18th, and 23rd, how many more people are we talking about? Another 10, another 100, another what? That you know of?
Just that I know of, I wouldn't even want to say, sir. There's a lot. There is a lot in this group.
More than 100?
Yeah, I'd say there's more than 100. Absolutely.
And you have obviously exchanged intelligence with this list, or with these people, right?
Intelligent what people say.
The other law enforcement that you've been talking
Absolutely.
about. Okay, and so obviously there's some sort of investigation which is going to have more than 100 people with some sort of connection to the plaintiffs in this case, right?
That's not what you asked, sir. It's completely false what you just said. What I said was that there's over 100 that are working together. I can't tell you what the investigation, once we get all the evidence that we've asked for, what it's going to bring, whether all 100 are going to be tied together or not.
There were, on June 23rd, there were a lot of items that were seized, right?
Yes, sir.
From a lot of people, some of whom were charged, some of whom were not charged.
Correct.
And just so that we're very clear about this, there were 16 warrants that I have, which we'll go through in just a minute, very quickly, Your Honor, that is requesting information from people's cell phones, as well as from people's YouTube or Google accounts. You're aware of that? Okay.
I don't know which ones are, if all of them, I think we've only filed 6 for actual YouTube accounts, but there's a lot more than that we didn't file, that we only filed on for the phones. That was a separate thing. Not everybody got it, so it shows that we're trying to distinguish between the two of what we need. And then there's quite a few more that we will be following in the future.
Okay. Your Honor, I'm going to be asking questions about some documents that I was emailed yesterday at some point in the afternoon. They are not a part of the case or file yet, but what I'd like to do is file them at some point later tonight, maybe tomorrow, as supplemental exhibits. These are the actual warrants. And then, in index of exhibits, I'll try to be as specific as possible as to what they are. I just don't know any other way to do it other than filing them and continuing this hearing to another date, which I know nobody wants to do.
You don't want to introduce them here now? I'm not sure I'm following what you're...
I can. Yeah, I can do that. Okay. I already marked up my copy, but I can do that. Okay, I'm going to hand you... There's
And again, I don't know that we need to go through a big song and dance, proving them up. If they've been, handed over in discovery and there's no dispute that they can come in.
We have no objection on it.
Right, okay.
City has no objection.
Oh,
Okay.
yeah.
Then I'm happy to just consider them, just,
Should I do letters or numbers? Okay. Going to hand you what's marked as Exhibit A. This is a 10-page document. And it's an affidavit for search warrant and a search warrant.
The purpose, I thought, was we weren't objecting, so we have no objection to do that.
Okay.
I'm going to ask him a question. I don't want him to feel like surprised or anything, so I'm just going to move it.
okay. And so you've marked one of these documents as Exhibit A.
Yes, this is one of the Google warrants.
And so since there's no objection to Exhibit A, I'll consider Exhibit A as introduced into evidence for purposes of this hearing.
Thank you. Okay, now, you'll notice that there's, on the very first page of that, there's 4 distinct YouTube accounts that are being sought by the police, right?
Yes, sir.
In fact, by Detective Terry Brooks of the Wayne Valley Police Department, right?
I assume that's his signature, I can't tell, but I would assume so, yes, sir.
Paragraph 680.
Okay. Yes.
Okay, so, and looking back at the first page, there's those 4 distinct names that are listed. One of them is Joseph Pierce, right?
Correct.
Other than Joseph Pierce being present on June 23rd, 2018, and recording what was taking place, there's no other evidence that he is part of this cabal, is there, that we know of?
I'm not sure I understand what you're asking.
What I'm asking you is, there's a warrant that's being sought on Joseph Pierce because he was present on June 23rd, 2018. Let me ask it this way. If he was not present and was not recording, there would not be a warrant with his name on it, true?
I can't say that either, because if we would, like the rest of the people, when we get the rest of this information, the people that there's going to be tied in a lot of people that we could eventually go get search warrants, and will eventually go get search warrants on, based on the evidence that we received from this case. So that's not true.
I'm talking about evidence that was received prior to this warrant being signed on August 7th. Prior to that, did you have any information? Would you have gone after Mr. Pierce's Google information?
No, he hadn't committed a crime yet.
Okay. So the only thing that happened that is now making his YouTube information something that your department is seeking a warrant on is that he was there on June 23rd recording, right?
Yeah, incorrect.
And his characterized testimony was previously given, right?
Yeah, I think that's an accurate projection. This question's been asked and answered a number of times.
Using the same example of Mr. Pierce, we're going to look at Exhibit B. Exhibit B is a 7-page document seeking a warrant for Mr. Pierce's Samsung Galaxy.
I assume, Mr. Progerio, there's no objection.
No objection.
Okay, and you want
Yes,
to court to consider this one as well? Okay, then I'll admit it B for purposes of this hearing.
Now, if you turn towards the second to last, third to last page. No. The second page. The second page of this.
Second to the last page?
No, second page, I'm sorry.
Okay.
It was earlier than I thought it was.
Okay.
It says that he's part of a group calling themselves First Amendment auditors. See that?
Yes, sir.
This is a group whose purpose it is to go into a police and government facility and try to create confrontation with police while streaming live with a recording device. See that?
Yes, sir.
And just so that we're very clear about this, that's the basis for this cabal, this group. Their goal is to cause this trouble. That's
not true. That's not the basis for the search. That's not what even says on the first page or any other pages.
Well, the other things refer to other. Well, let me ask you this. What's your understanding of why Mr. Pierce's phone is something that the police want to see?
Mr. Pierce was a witness to a crime. There's original evidence on it. We want to see his phone and the contents of that phone so that we can recover that original evidence.
Okay, so is it because he's a witness or because he's a part of this group calling themselves First Amendment auditors?
People can switch back and forth between witnesses and suspects and arrestees multiple times. As of the date of this, he was a witness to a crime. He definitely is suspect in other crimes, and we definitely intend to make him an arrested person in many other crimes.
And why is it that it's mentioned that he's a member of this group, First Amendment auditors? Why is that important?
It's important to show that there's collaboration between the group, and we can show that there's complete collaboration between the group and their methods and tactics.
Isn't it your position that if they're a witness to a crime, that's enough? Why don't you just say in the warrant he was a witness to a crime? We need to see what's in his phone.
Helps us and helps the judge understand the severity of what we're dealing with.
But based on your understanding, that would have been sufficient to just say he was a witness and therefore we get to see what's in his phone.
I didn't say that. I said the whole document is written up to give the judge a good idea of the circumstances that we're dealing with. We wouldn't want to lie to the judge. We wouldn't mislead the judge like you stated before. We 100% want to make sure the judge understands the severity of what we're dealing with, that at this time in this document we're asking for him was as a witness.
This statement that he's part of the First Amendment auditors implies that he's a suspect, doesn't it?
It implies that he's a member of a group that call themselves First Amendment auditors.
Right, but that's included because
he's a member of a group called First Amendment auditors.
Right,
it's included.
So was he a witness or a suspect or both?
I think the whole document calls him a witness.
Chief, in your view, is a probable cause determination made by carving out a situation from all the surrounding circumstances and isolating it, or is it a call that's made based on the totality of all the circumstances?
100% the totality of all the circumstances, which is why I say that there's a lot more going on than what counsel would lead you to believe.
All right. I have nothing further.
Okay. Mr. Frugerio.
Thank you, Your Honor. Chief, would you please give us a little bit of your background in law enforcement?
Absolutely, sir. Spent right at 29 years with San Antonio Police Department. Rose to the level of captain. My final assignment was as the commander of the Airport Police Department. So I ran a separate police department. It's the only captain position that allows you to do that. Prior to that, I was a patrol officer on the west side of San Antonio. I was almost 6 years on the SWAT team. I went undercover as a narcotics detective for 3 or 4 years. Became a sergeant and ran a community services unit. And eventually became a lieutenant, where I ran the tactical response unit, where I had 100 people assigned to me at the tactical response unit, and we investigated all kinds of crimes. Violent crimes was our specialty, and we targeted the worst of the worst. I also, and then as a captain, I became a captain and went to the airport as the airport commander. I have been the chief of police for Leon Valley for the last 2 years, as of September 15th, feels like 20. But on top of that, I have 29 years, 4 months, and 15 days in the military. That military service included traveling across the world. I was in charge of all the organizing, training, and equipping of all the law enforcement personnel being sent to war. I went over to the area of responsibility on multiple occasions, met with my people, and made sure that things were going correctly. I'm a planner by trade and by everything I do, and there's a lot of planning that's gone into this from the first arrest up to today. So,
Chief, tell us about your force at Leon Valley. What is the size of your police department?
With a 3.5 mile size city, our police department, at the time of this arrest, I think we were somewhere around 35 or 36, and we've since grown to 42, I believe.
How many of those are involved in criminal investigations, such as detectives?
We have 3 detectives that are involved in criminal investigations, and I have 1 detective that runs the impound line, and a supervisor over those that doesn't do the investigations.
How has the City of Leon Valley Police Department and the Municipal Court building atmosphere changed since May 2nd of 2008?
Completely changed. Once we began to, from the moment of the first arrest, I didn't have the arrested person.
Who was the first arrested person?
Jesus Padilla. I didn't have him walk over to the actual jail cell when the phones lit up. Didn't know anything about this group, didn't know anything about their activities, had never heard of them before. And I was walking them to the jail, and my secretary said, "Hey, Chief, you're on YouTube Live." My answer was, "What's that?" I kept walking, didn't understand at all. So put him in the jail cell, and we started, every phone's ringing in the building. We find out after that the tactic that they use is they go in with your phone number on the screen. There's thousands of people, hundreds to thousands, depending on the subscriber. And as soon as you put hands on that person, they light up your phones, and the death threats and the vulgar comments to everybody in the building begins.
Okay, now that was May 2nd of 2018 this year, correct?
Yes, sir.
Okay. Now, can you describe for us the building, the municipal court? There's like one main entrance to the offices at Leon Valley. Could you walk us through that?
There's one main entrance into municipal court. We have several entrances. It just depends. We have it segmented into the difference of the workload kind of thing. And so this area, as soon as you walk through the door, it is municipal court. The judges deemed it areas essential to the court.
Are there signs posted similar to the signs posted in this court?
Yes, sir, there are. There are signs, and the judge's order is posted as well, so that there's no misunderstanding of the fact that this is a municipal court area.
What is the order of the municipal court judge state?
The order, without in front of me, sir, it basically sets the court decorum, what people wear, when they stand up, when they don't, those types of things. It also says that there's no cell phone use allowed, no videoing in the courtroom or areas essential to the court.
And this is the area that we're talking about with these 3 instances.
Absolutely it is. Absolutely.
And that's actually where the municipal court is located. So as soon as you enter the building, is it right or left where the municipal
There's a lady detective at the area to your right immediately when you come in. She takes municipal court payments, processes different things. And the area straight to your front is municipal court. And that area is a very short distance, probably from me to you, between the First Lady and them. And so it's a very small area. There's a lot of privacy things that go on in this area, which is one of the reasons that the judges deemed it essential to the court and does not need the disruption that this group loves to cause. Now,
at one point during this litigation, you provided to I'm your current counsel, correct?
Second,
I'm the attorney representing you individually.
Yes, sir.
You provided to me what has been entered in evidence in this case in docket 48, Exhibit E, which is a representative of a social media account of threats made to the city and your family and
Small representative, yes, sir.
And where did you obtain that
from? Some of the stuff I myself got right off of YouTube. The stuff that's on James Springer and Val's account is still there. Jack Miller's account is still there. Others went away, so we had to rely on, there's police officers, civilians from across the world that are notifying us now and watching everything that this group does and notifying us. We've got calls from as far away as Canada when there's criminal activity. In fact, the death threat week before last that was on me, I didn't never see it. The Canadians are the ones that notified the FBI, and we were notified of it, that death threat.
May I approach the court reporter first?
You may.
D1. Yeah, approach me.
You may.
I show you what has been marked as Defendant's Exhibit D1 and ask if you can identify that.
Yes, sir.
What is that?
That's a picture that was taken off of the website, the YouTube account that was live streamed by Mr. Bowlin over on the left, of a meeting that was in Jack Miller's kitchen that I recognized because of the search warrant that we ran on his house. And it's a large group. Basically, everybody except one in this picture are defendants. And
who is depicted in the photograph?
from left to right, as I wrote on here for you, it's called YouTube Clash with Val on June 19, 2018, which is before the arrest on the 23rd. Left to right was Val Lynn, Joseph Pierce, David Bailey, James Springer, Jesus Padilla, and Mark Brown.
Try to move for the admission of Defendant's Exhibit D1.
Okay. Any objection?
Well, just that there's 7 people and 6 names. But no objection to the admission of that.
Okay. Thank you. It'll be admitted for purposes of this hearing.
Chief, could you explain to the court the importance of obtaining the information from the cell phone?
Yes, sir. And I did leave off Jack Miller. I wasn't going to go like that. My apologies.
Okay, Jack Miller on D1.
Yes, sir. He's next to the right. So it should have had Jesus Padilla, then Jack Miller, then Mark Brown. I don't have him feel left out.
With regard to the cell phone, what is critical as far as the information you need for your criminal case?
The original video is extremely critical. The text messages, the original text messages that are coming in to show the coordination of the group in their criminal activity. Their accounts, their email accounts. We know and have a lot of their email accounts where they show where they request people. We can't see it because they're removing the comments, so that we can't see it as it's going along, but they're telling people, yes, that's a good idea. For instance, email me that. We don't know what the comments and what they were getting emailed or what was said because their moderators are controlling that, and they're controlling that while it's in their hand. They see it a minute or so prior to everybody else, and they can make the determination. So all of those things are somewhere in their phone. The text messages for sure, the phone log, if there's something when they're calling each other, and the original original videos from the incidents.
Are IP addresses important?
They're extremely important. We definitely want to, as the council stated, we definitely want to get search warrants on all the rest of the people that committed the threats. The interstate ones we're already turning over to the FBI, and they're working on those. It's the local ones or the state of Texas that they've asked us to work on because there is so many threats. And so the IP addresses are going to help us track down people and exactly where this threat came from, and it's going to help further the investigation to get the people that were illegally submitting my family's information, my information, and all the death threats on all of our employees.
Is it important to identify the moderators also?
Absolutely.
What is a moderator for the purposes of the record?
So the individuals that own the channel, they can assign people a wrench, that's what they like to call it, for their mods, as they call it, but it's a moderator. And that moderator, like them, can see the comments that are coming up ahead of time, and those people are supposed to help take away things that they have, their channel owner has given them direction to take away. And what we began to see from almost the beginning is that the pro-police things are taken off of their channels, but the death threats and the anti-police and the submitting of people's addresses or attacking anybody that is on there that's anti-police is left up. So it shows that there's an intentional desire for them to leave this stuff up and to leave the threats and the death threats up. And then when they get off of it, they can turn it off and delete, or not even post that, delete that thing altogether. So the moderators are extremely important. We know, for instance, James Springer, who goes by James Freeman. His wife is a normal moderator. It says Mrs. Freeman, but until I look at everything from YouTube, I will not know whether or not that's Miss Freeman or not.
Approach witness now.
You may.
I'd like to show you what has been marked as defendant's exhibit number 2 and ask if you can identify that.
Yes, sir, I can.
What is it?
Okay.
Could you please explain to the court what D2 is?
This is a very small portion of a video that James Freeman posted on June 23rd, 2018. He was streaming live, and he named this "Protesting the Sovereign Citizens."
Now, Mr. Freeman is also, what is his real name?
James Springer is his real name.
He's a plaintiff in this lawsuit.
He is a plaintiff in this lawsuit, sir.
You've described to the ladies, to the court, the multiple death threats that you and your family have received.
Yes, sir.
And did you not, in fact, download one of the ones you received this week?
One of the ones that came on my phone Monday, I did download.
Just to clarify, I'll accept into evidence D2 for the purpose of this hearing.
Thank you, Your Honor. Your Honor, I've marked what is defendant's D3. I only have one copy of it. It is full of vile language that I wouldn't want necessarily play to the court, but I would like it submitted to the court as something that was received by Chief Salvaggio.
Okay, and has Mr. Radner? Okay, well, just to confirm. You want to let him take a look?
Sure.
Take your time.
Play it loudly.
I don't mind if you play it out loud for the court, right? I just don't want to get rid of it.
No, it's okay. No, it's all right. Take your time and review it. Okay, and just for the record, so we're looking at what's been marked as Defendant's Exhibit D3. Mr. Radner is just going to review it, see if he has any objection before we get into it. Chief Salvaggio, in your experience, it's pretty significant experience, law enforcement experience, is this an unusual set of circumstances where you have a department that's experiencing these kinds of difficulties with respect to the magnitude and nature of these protests, or interference, or however we want to call it, these activities? Is this out of the ordinary?
I have never seen anything this in my 31 years.
And you testified that, as I recall, you said something that sort of all of this is really interfering with investigatory functions. And that includes, I take it, not only this lawsuit, but also these other activities that precipitated some of these charges. So what's interfering with your office and your department is, in your view, this entire set of circumstances, including these activities, phone calls and protests and all that other stuff. Is that right?
Absolutely, sir.
And it's been to the extent that folks even who would normally be processing files or processing warrants or doing other things like that, those activities have been curtailed or interfered with as well?
Sir, I'll tell you, myself, I've not had a day off in months because I spend the weekend doing the open records stuff. My guys have been assigned individuals now to monitor every one of their stuff, and we have to download it and catalog it, and it is completely, my city manager cannot go home because the death threats received, it was placed on her. My family, I had them out of my house for weeks, or 10 days or so, because of the death threats on my family and the constant phone calls that go to my wife that was released on their channels. It has disrupted my life, my family's life, and every one of these officers' lives, and it's exactly what they intended to do. They have not stopped this activity. They've moved on to other agencies. At this time, Denton's one of their ones in their crosshairs, and there's multiple others. There's been arrests constantly of many members of this group in states. James Springer, for instance, has felony charges pending in L.A., where he's a fugitive from justice in Los Angeles. He has stuff from Arizona. He has stuff up in Dallas, in Crowley, and now here in San Antonio. And he has no reason to go to any of those other places except that he answered the call from other auditors of the tyranny of the police department. And they go down and we're going to teach them a lesson. And that lesson is to destroy the inner workings of an organization, and they have done just that.
And there may be, to some extent, portions of this activity that are protected by the First Amendment. It's not your position that these are not First Amendment activities necessarily until they cross the line into criminality.
Absolutely, sir. They were at this time, they were there 11 days straight. We only made arrests on 8 of those days. And 2 of those arrests were late in the afternoon. And they'd been out there all day. They'd live streamed for hours. And we never even confronted them. The direction I've given my officers and the training I've given my officers is do not arrest if you can keep from it. But at some point, after they continue to push and push and push, some point you got to do something. And the worst part about it for me, Your Honor, is they're telling everybody else out there in the cyber world that this is how they can act. This is how they can treat judges. This is how they can treat police officers and their families, because it's protected. Threats to families of police officers and judges is not protected. But unfortunately, by their own words, they say and they tell them it is okay to do these things. And we'll easily be able to show that in court.
Chief, to correct the record, you're speaking of 11 days. There were only 3 of the 11 days where arrests took place.
Correct. The other 8 days, there were protests. They were left alone. We never had any contact. Well, I take that back. On multiple occasions, I went out and offered him food and water because that was hot. He kept saying he was so hot. So I took him water, and another day we fed him. We fed him the night they were arrested. It's not personal. It's not personal now. If my family gets harmed, now it's going to be personal. But I'm telling now, sir, it's not personal. It's professional. We've maintained that professionalism. We've done arrests only when it was necessary, and we will file charges after the fact. And that's exactly what we're trying to do now.
Have you had a chance to review the material, Mr. Radner?
Not yet.
Okay.
Can I do it now?
Sure. Sorry. Yes, you can.
I reject the admission of this simply because there's been not a shred of evidence or testimony in any way at all connecting this voicemail to any one of my clients.
Okay, well, let's just see if we can have a foundation connecting it to.
Well, the foundation is part of these First Amendment auditor protests spurring these things on, and this is representative of one of the hundreds, if not thousands, of phone calls that have been received by City of Leon Valley officials, including Chief Salvaggio.
Okay, so this is, just explain to me the context of, I mean, I heard a voice come on and it sounded like a phone message, but it's a message where and when and, all of that stuff. Just so I know.
Chief, where was that phone message received at?
It was received on my desk home. What had happened the night before and that afternoon, Black Label, Coke Watch, whatever his name is, and Jack Miller released a video that showed the arrest of Jack Miller on an arrest and search warrant of his home. And they played it real big. As soon as they posted it, phone calls started coming. The death threats started coming because they re-energized those people. They don't in any way make it look like this is 2 months old. They post these videos as if it just happened. And it makes them angry. They start all over. So just shortly after Jack Miller posted that, your defendant, is when I got this phone call.
Do we know who it's from?
No, sir. But he called anonymous. He called where we can't see his phone number. We'll have to get a search warrant to eventually go into that.
Okay. Well, I mean, you played it in open court. I heard it. I've heard that he doesn't know, that the witness doesn't know who left the message. So, you want to maintain your objection? I mean, I've pretty much heard it already. And it's only going to come in for purposes of this hearing. It's just coming in here today.
Did we get a date from this?
This was Monday.
Which would be October 1st, 2018.
Yes, sir.
Okay. All right. So we okay now?
Well, no, I think obviously it wasn't what I gave my client's cell phones that are in the police possession, so I still object. And also, even in his explanation, he said that this message came in after a video was posted.
Okay.
He never said that any of my clients told this person or had any communication with this person to do it. This person was acting on his own in response to the video that was posted.
So your objection is relevance. There's no evidence you contend tying this message to any of your clients?
None whatsoever.
Okay. The objection is overruled. I'll consider the evidence for purposes of this hearing. I understand the objection and understand that there isn't anything in the record at this time tying that message to any one of the plaintiffs in this case.
Thank you, Your Honor. Could you please explain to the court your understanding of the YouTube process and how it can be a money-making enterprise?
Sir, this, again, as we talked earlier, hiding behind the First Amendment, this is all about money. Everything they do is about money. They get paid for the subscribers. they get. So the more craziness they do, the more subscribers they get. The more crazy things they do, people donate money. Each time somebody goes on there, there's advertisements depending on how many subscribers you have. So the more subscribers you have, you make money off of the advertisements. And then, Bow and Springer and several of them have even gone further, and they've actually been able to monetize people being able to make comments. So people will pay $10 or $20 to be able to make a comment and have it be read online. So they like doing that in open hearings and buildings and things like that, so that the vulgarness disrupts the entire atmosphere. So they're making money every single day, every single hit, every single advertisement, every single one of these. They're making money. When I was in jail, they raised, from what we could see, it was close to $10,000 according to them. They have listed 5 or 6 different ways that people can donate to them. I think on Bow there's like 6. Some don't even know what they are. Bitcoin, and I know that, but Ethereum and all these others. It's all about. I walked out today, and Bow had his stuff on, and out loud it said, "I'll give you somebody paid for it to go out loud to say $200 to go kiss Chief Salvaggio on the lips. So it's all about making money. Is really what it's about.
In this Bow that you referred to, has he been convicted in Tarrant County?
He has.
On what charge?
Harassment of a judge.
With regard to what we're here about today, this hearing on the temporary injunction, if the court were to grant a temporary injunction with regard to the cell phone, would that interfere with the criminal investigation that you have instituted?
Can I answer one more thing before you answer that? To say Val's not involved, Val just left, so we're clear. He was just here. He was out front earlier in this pink police outfit, fun piggy outfit. So if the injunction was granted, it would absolutely interfere. In fact, it would allow many people to escape the full carriage of justice. I would not be able to file criminal charges on multiple people, including some of their own defendants. I truly believe 100% that's the reason this is being done. I've never seen a civil case be filed before a criminal case is completed, before we've even been able to begin the investigations and feel them out. We will not in any way be able to go after multiple people if we're not able to get to the internet stuff, that multiple videos that we have not seen that have been deleted that people told us about. If you look at the preservation order on the first day, on June 23rd/24th, this is a fraction. His defendants are a fraction of who we're going after. And it would impede that investigation wholeheartedly. 100%, sir.
Thank you very much. I'll pass it with you.
If I understand it correctly, there's...
I think the city has a question.
Oh, I'm sorry.
All right, may I approach the witness, please?
You may. And let me, while you're doing that, Chief Salvaggio, the preservation order you mentioned, this isn't an order directing the Google to preserve. Can you just explain what that is?
Yes, sir. And I think, are y'all going to put it in the record, sir, or
Yes, I could introduce it.
Okay, well, why don't we just do that then? Just so I'm up to speed entirely on what we're talking
That was my second exhibit.
about. Okay. And assuming, again, subject to objection from complainants.
Your Honor, this is June 14th of one of the police officers. This gives another view with regard to the arrest of Mark Brown. For the record, it's 2018-06-141-35-1070.
Okay. And I'll accept that, and any other videos that have been played in open court, I'll accept them for the purpose of this hearing. Is it updating?
It's,
It doesn't have to move.
yeah, it's, let me do the other ones and then I'll do this one last.
Okay.
It shows another angle. Okay. So, it's just, I have to agree. Oh, that's nice. Yeah.
You've got it?
Yeah.
All right.
The generation.
I agree.
And this is, just another angle, and this shows how busy the hallway is, the foyer is.
Okay. Just hoping we move this one. I don't have to be that far. Make sure everybody can see.
And for the record, sir, all those people were previously just standing in that hallway out there before the judge opened and let them come in.
Okay. And this is a body camera?
This is the body camera, probably of Officer Azar, but I'm not sure.
No, you keep going.
Yeah, it is Officer Azar. And those are all
No,
people.
the prosecutor? Yeah, the prosecutor.
And she's going to go outside and you can see the officer confronting.
Sir, we're having business, go ahead and step out. Sir. Step out, sir.
I see him filming.
Okay, yeah. Let's do it.
He's already disrupted.
Can we conducting business in here so we can't have... You cannot tell me. Okay, now stand here. You can stand here. You can stand there. Stand over there. I'm standing right here, guys. Don't ever put your hands on me again, sir. Don't ever. Okay? You have no right to. Lieutenant.
Also, let's do it.
LT.
No, that's it.
That's good?
Yeah, that's just another.
Okay, thank you.
And so that demonstrates that one camera angle tells one story, another tells another, and to have a complete story, we need all the original evidence.
Chief, I'm going to hand you what is going to be marked, I guess, Defendant City's Exhibit A.
All right, so we've had defendants 1, 2, and 3. Now we've got defendants cities A.
A.
Okay.
Chief, you described the document I handed you. Defendant City's Exhibit A.
So this is a copy of the preservation order and some email traffic that went back and forth between Google and my detective Jimmy Wells. On the night of the 23rd, I've been preparing already based on some of the threats and the things that we've been seeing throughout the week to document a list of names that we needed to investigate further. That night I gave those over to Detective Wells. It was pretty late, 6 or 7, I guess, and he began the notice of a preservation order because we intended to further investigate everybody that's on this list and eventually ask for search warrants and arrest warrants based on the evidence that we would be able to uncover from the onslaught that we had just went through over the 10 days prior.
This way, if there's any objections from the planning.
Okay, so this is the preservation order, so this is defendant city A. You had a chance to look at it, Mr. Ratter?
I have no.
Okay, thank you. All right,
How it's going to be later, so.
okay. Yep, defendant city A.
I'm sorry, Your Honor. And I would like to say this is one of the items that really bothers me about this civil hearing here, because now every one of these people is going to be on record and they're going to be able to run back to these people and say, you're under investigation for state and federal charges. Because most of these people here are listed on here, on this list. They didn't know they were under investigation for other charges. And all the other people that are on this list that have not been arrested yet did not know they were part of this. And now they will, based on the evidence that is given to Mr. Ratner.
Well, Your Honor, then what I'll do is I'll withdraw my exhibit, and we could just use it for demonstrative purposes to inform the court of the letter, and I'll just retract my exhibit.
I don't think you can unsee it now.
It doesn't say any of this stuff you just said it says. This is simply not asking people to maintain certain videos and comments.
The police department wouldn't do that unless they're investigating. And it was on the 25th on this one. The original was filed on the 24th, so that shows you how long in advance, way before this lawsuit was filed, way before their orders were filed. This was already our intent and was filed with Google, was the investigation of all these people that are his defendants.
I leave it to the court,
Well,
I'd like to withdraw
Mr.
it.
Reeves, it's your,
Yeah, I'd like to withdraw it. It was just for demonstrative purposes.
it's withdrawn.
Do I not get a copy? No. You do not?
No, you can just keep that right now. And Chief, I think you explained that it was done, letter was done earlier, is that correct?
They were doing it the night of the 23rd when the felony arrests were made.
And is it my understanding that you had to do the letter again because there's a certain format that they required?
Correct. They filed the first one at 0015 hours on the 25th, or 24th, I'm sorry. Google came back and said, we've got a new updated process. You need to file it like this. So on the 25th, they refiled it according to what the Google people wanted to see.
Honor, may I approach the witness?
You may.
Yes, sir.
Chief, I'm going to mark that as, since we look through the other one, we mark it as City Defendants Act.
Yeah, I prefer if this is marked as BCB, and BCB remain one that was withdrawn. We need not to ask questions about BCA.
Yeah, that's fine, let's just keep it, let's make this one B.
Chief, can you describe that document?
These are copies of the charge and disposition reports. Police officers call them CMDs. These are the documents that once we file the charges, we take the case file to the district attorney's office. They have an intake person that looks at the charges and make sure everything's there, and then they timestamp it and initial off on it when we turn the case in.
And you testified earlier that some of these cases have been refiled, is that correct?
Correct, sir.
And from the document that you have, he lists the names of the plaintiffs whose cases have been refiled.
Jason Green, his charges have been refiled, 2 charges. Brian Howe, 2 charges have been refiled. There's one here for Jack Miller, but it is his original charge. Bao Lin, this is his, this is the original felony charge on Bao.
Yeah, and Mr. Mr. Wynn is not a party to this.
Correct, he's not a defendant. Joseph Pierce, who is a defendant, his case is a refile, and this charge on James Springer, which is a defendant, has been refiled, and this charge on James Springer is the original, and it has been filed as the felony. It's not a refile.
So the refile goes to the misdemeanor charges, is that correct?
Yes, sir.
Okay. And I think you testified that usually you'll get some of the charges back, but it's not unusual. You go ahead and refile. And so these are pending right now, the ones that are not the original ones, but the ones that you mentioned for, I guess, Springer for the misdemeanors, Joseph Pierce for his charges, let's see, Brian Howd, and I think I can correct the record, but the plaintiff is Jonathan Green, is that correct? Very fine. Yeah, it's Jonathan Green. So Jason Green is a non-party to this case. Okay, so with regard to these individuals, have you heard have you received, well, what will you hear from the district attorney's office? Do you get a copy of an information, or how do you hear from them?
No, we don't get information or an indictment. We don't know what happens until we get a subpoena, or we get a notice of what they call an ICR, incomplete report, and there's additional things they need us to bring to make that case complete. We also could get an outright rejection saying that, and they'll write on there the reasons they don't believe this case is going to go, which is not always that it wasn't they were guilty, it was just they didn't want to take it forward for whatever reason. So we have not received any rejections. Those cases have been filed, and as far as I know, they're continuing through the court system today.
So now let me just make sure I'm understanding. When you say that charges are filed, what you're referring to is that you pass them on to the prosecutors, or there is an actual criminal proceeding that is ongoing?
We pass it on to what's called the intake. You have a felony intake and you have a misdemeanor intake. Okay. The felonies we would file with the felony side. We don't know at that point we don't know who the attorneys and prosecutors and courts are going to be. So the intake, the felony intake, we take them there. The misdemeanor, we take them there. And then we might get a call, however long it takes, which it takes time, sometimes a long time. Now that they're looking at it, they might call. We might get a call to the detective to say, "Hey, on this case, I really need you to go to this witness's house and get a statement." Or they might send somebody themselves to go get that statement. Or we might get it where it says this case has been rejected and here's the reason why. So it's going through the system. We have knowledge now of who most of these cases, I think all of these cases, we have additional charges that have been filed that are not listed here as well. And so those cases and these cases, as far as I know, we know what court they're in and what prosecutors dealing with them, but I can't tell you 100% what's the status of them. I just know they haven't been rejected or we would receive a rejection.
But there is at some point an additional step, which is where you have a formal charging document that's going to get. Is that right? Or am I just...
On felonies, yes. On misdemeanors, especially on arrest, they normally don't. They just go off the arrest. But if they want to, they'll go up and ask for an information. If there's some questions on it, they'll run that in front of a court for information. But from what I've seen, that's rare to actually go ask for the information. They usually go straight off of the packet that we turn in. And if they feel that there's enough to actually go forward with those charges, they will get a warrant. If they haven't been arrested yet, they'll get a warrant, and that person will be picked up and brought into court.
So no further charging document is filed?
Not that I know of,
okay.
But I'm not 100%.
Okay, no, thank you.
And Your Honor, I'd like to introduce as exhibit B.
Without objection.
Okay, thank you. All right, that's city defendants B, as in boy, and I'll accept that evidence for purposes of this hearing. Thank you.
I have no further questions.
Okay.
Looking at Exhibit B, these were submitted to the prosecutor for the most part on July 17th, right?
Yes, sir.
Now,
No, hold on. Not to the prosecutor. They were submitted to the intake, not the prosecutor,
the intake at whose office?
at the district attorney's office.
District attorney's another word for prosecutor, right?
No, I don't know. That's the district attorney's office. It's not a prosecutor that was there. It's a civilian clerk that handles those.
You usually take them 2.5 months to respond to these intakes?
Oh, absolutely.
Oh. Now, did you also tell the district attorney's intake people that the magistrate has already rejected some of these charges?
Oh, absolutely.
Oh,
Yeah.
you did? Okay. Because it's not contained in the exhibit.
It's not relevant.
Okay. But what I'm saying is whatever it is that you submitted to the district attorney for review for their intake, you also included the fact that the magistrate has already rejected some of those charges, right?
That's not relevant, sir. What we submitted was the evidence that the case should be tried on. If that evidence is good enough, they go forward with it.
I thought you just said a minute ago, I'm not trying to argue with you, I just want to get to the bottom of this. Did you inform the intake people at the district attorney that some of these charges have been rejected by the magistrate?
No, we don't inform the intake. No, absolutely not. It's not relevant.
Exhibit A, or I'm sorry, D1, the 7 people in the picture, you said there was a meeting that has taken place.
Yes, sir.
How do you know there's a meeting?
That's what they call it
Where did they call it that?
on the video.
You watched the video.
Yes, sir.
Did you maintain a copy of that video?
Yes, we have it.
Excellent. And what did they discuss at that video?
I
At that meeting?
have no idea yet. We hope to find that out when we look at their cameras. Me and them were arrested after that.
Oh, so you're under the belief that there's going to be something about in their cameras or their phones that talk about that?
There could be some coordination in the collaboration that the crimes, organized crime, would be in there.
What date did you take this picture?
I didn't take that picture.
What date did you create this piece of paper?
It was created a couple days ago off of YouTube.
What date was the meeting?
It was listed on this or whatever.
June 19th is the date of the meeting?
Yes, sir.
Okay, because it says YouTube clash with Bo, June 19th, 2018.
Correct.
So it's not that it happened later and that it was referring to this YouTube clash. It was that you're saying that this meeting actually took place on June 19th.
According to what's on YouTube, yes, sir.
You have no idea what was discussed at that meeting?
Absolutely not.
That threat that we heard, do you have any evidence at all from anything that you've seen that any of the plaintiffs in this case are the voice on that?
No, sir.
Any evidence that they corroborated in any way with the person who left that death threat?
Not at this time.
If I understand it correctly, the only connection that we know, based on the evidence that we have, is that the video was posted, and then shortly after that, the message came in.
Correct.
What phone number did the message come from?
Again, anonymous or whatever or private or whatever is anonymous. It didn't show up on there, so I have no idea.
Even though a voicemail was left, it still showed up as a block number?
Yes, sir.
But just so we're very clear about this, there's no evidence linking that video to the plaintiffs, right?
Correct.
That audio was what you, that okay.
Yeah, correct. Not the video. This D2, do you still have it? The
Yes, sir.
4-page. These are screenshots from YouTube with very disturbing things, such as Skorp Kitsan, Skorpkitsan, who put your address there. You see that?
Correct.
Okay, now, again, Your Honor, I will offer to the court that if they want to reissue a subpoena to Google, sending it to James Freeman, my client James Springer, asking for Skorp Kitsan's information, I will agree to that. However, again, it's our position that, well, let me ask you this. Skorp Kitsan is the person who posted this, right?
Probably his name is not Skorp Kitson.
Probably.
I have no idea who that person was. Is why I need the original evidence. It's on Google. That Google has.
Well, let's not get in a fight again about who posted what. I mean, I think we cleared that up before. That there can be a distinction
Okay. I'm going to ask
I
one
think
question
we're all on
about
the
this
same
just
page.
because I think it goes to the purposes of good faith.
Okay.
Wouldn't it make more sense to submit a request or a warrant to Google requesting Sport Kitson's information and not James Springer's information?
We're going to get there, sir.
Can you answer the question?
I just did, yes, absolutely. We're going to get there for all of these. But we've stopped because of all of this mess.
But you can get everything you need by subpoenaing Sport Kitson without going after James Springer, right?
No,
No?
it's not true.
Yep, we've been down that road too.
We have,
Okay.
just so we're, thus far you submitted a warrant request for, an affidavit, a warrant for James Springer, but not for Sport Kitson, right?
So Sports Gibson is being investigated by the FBI.
Can I just?
So the answer is yes. No, I'm not. Sports Gibson is being investigated by the FBI because it's considered interstate. And I'm not sure what they have done with it. If they find that it's a person from the state of Texas, then they will give it back to me. So I can only assume at this point, since they haven't come back to me on it, that he doesn't live in the state of Texas or they got something different. I don't know.
The video that we played, that the city lawyer played for,
Audio or video?
the video, the actual video that we saw, where Mark Brown is being told to leave the building.
Yes, sir.
Was there a video that I showed you of him leaving the building from a different angle?
Yes.
I thought the video that I showed you was him outside recording an arrest.
No, it was more than that. It was, you only showed me, I don't know what all's on that video. You showed me a segment of that video to make it look like he was just minding his own business.
Okay, let me ask you this. You testified that you watched video that showed Mark Brown lording over the arresting officers. Remember that?
Yes, sir.
That's not the video that your attorney showed us.
You can see his arms over him when Sergeant Odialis turns and goes back. You can see his arms up in the air, and he's too close for comfort for a police officer. He didn't stay where he was told to stay. He continued right behind the officer, screaming and cussing him out. So yeah, he was lording at 6'8" over the 5'8"-ish officer.
Did the lording over take place during the arrest in the video that I showed, or in the video that your lawyer showed of him leaving the building?
Or the video that the lawyer showed didn't show the arrest. The video showed the stuff before the arrest. So the lording that was in that video was of before the arrest.
Okay, I thought that what you testified before, and correct me if I'm wrong, is that during the arrest of Jesus Padilla, Mark Brown was lording over the officers, and that's how he was interfering with them, right? Wasn't that your testimony?
I don't recall that being my testimony, sir.
Okay.
What I said was during the arrest, which is this whole thing that's going on, all of that is pertinent to the investigation.
Okay, I showed you a video before of Mark Brown videoing the Jesus Padilla arrest on June 14th. Do you remember that?
Yes, sir.
Okay. And you said that since I was playing the video from the middle, we didn't see the part where he's lording over the officers during the arrest.
Okay.
That wasn't your testimony?
Not that I recall. But if it was my testimony, it was not during the physical arrest of Padilla. But Padilla's arrest started long before that. When he noticed that violation, Sergeant Odialis went back inside. The arrest was the whole process. And he was lording over Sergeant Odialis during the arrest of Padilla.
Let me ask it this way. The arrest of Mr. Brown for interfering with an officer,
Yes, sir.
when did that interference take place? Because I thought before
Well,
you said it was
I'll
during, I thought it was during the Jesus Padilla arrest. So just tell me when it is that interference actually took place, when he committed the crime of interfering with a police officer.
So what I'll tell you is he committed it several times. When he was told where he could video from, gave him specific orders according to what the DA's office has asked us to do in these cases, gave him specific orders of where he could videotape from. And as soon as he turned around and came right back on his back, screaming and hollering at him, that's interference with the duties. He's already interfered with the duties of that sergeant. He continued on when Sergeant Odialis came back out, following Sergeant Odialis. He's interfering at that point. He's not doing what he's been advised to do by an officer. And then he continued right on the back of that officer. So there are multiple points where that interference occurred. Quite honestly, he was interfering from the time he walked in the door with the duties of a police officer. You hear him arguing at the door where the officers are telling him he needs to leave. He's interfering at that point. So the entire time, he's interfering with the duties of a police officer.
Well, I guess the videos will speak for themselves, but your testimony is that when he was told to go record from somewhere else, and instead he started walking back towards the building in the video that your lawyer showed us, that was a crime of interference. That's your testimony, right?
No, it's not.
Oh, it's not.
He wasn't walking back, and that's a misrepresentation of the fact.
Let me ask it this way. What your lawyer showed us
Correct.
was a crime of interference?
Absolutely.
Excellent. Okay. I have nothing further, Your Honor.
Okay, thank you.
Nothing further on that.
And I'm sorry, if you could just be clear on the record, we ended that video at 1:51. Is that what you all recall as well?
That's correct.
Okay. I just want to be very clear.
Okay. All right.
Thank you.
Thank you, Chief Salvaggio. You may step down.
Thank you, sir.